ಪಾಸ್ವರ್ಡ್ ಏನು? ಹಲೋ, ಡೈರೆಕ್ಟ್ ಸಿಸ್ಟಮ್ಗೆ ಪಾಸ್ವರ್ಡ್ ಹಾಕಿದ್ದಾರೆ. ಪಾಸ್ವರ್ಡ್ ಏನು ಸರ್? ಸರ್ ಸರ್ 1 2 3 ಅಷ್ಟೇನ ಆಯ್ತು.
ಇದು ನಮ್ಮ ಹಾಕಿದ್ದೀವಿ, ಇನ್ನೊಂದು ಸಬ್ಮಿಷನ್ ಇದೆ ಅಂತ
ಸರ್. ಇದ್ರ ಲಾಗಿನ್ ಪಾಸ್ವರ್ಡ್ ಏನು ಸಿಸ್ಟಮ್?
ಹೇಳಿ ಫಸ್ಟ್ ತಗೊಳ್ಳಿಲ್ಲ ಅವರು ರಿಸರ್ವ್ ಜಡ್ಜ್ಮೆಂಟ್ ಅಂತ ಕೊಡ್ತೀವಿ ತಗೊಂಡು ಇಲ್ಲೇ ಕೊಡ್ಬೇಕಾಗಿತ್ತು ನಾವು. ಸರಿ ಈಗ ಅದು ರಿಸರ್ವ್ ಆಗಿತ್ತು, ಕೊಡಕ್ಕೆ ಹೇಳಿದ್ರು ಕೊಡ್ತೀವಿ.
ಕೊಟ್ಬಿಟ್ಟಿದ್ರೆ ಫೈಲ್ ಎಲ್ಲ ಕೊಟ್ಟು ಕಳಿಸಿದ್ರು, ಅದು ಪುಟಪ್ ಮಾಡಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟಿದ್ರು. ರಿಸರ್ವ್ ಆಗಿರೋ ಮತ್ತೆ ಚೇಂಬರ್ ಅಲ್ಲಿ ಇರ್ತಾರೆ. ಡೈರೆಕ್ಟ್ಲಿ
ಹಾಕ್ತೀವಿ ರಿಸರ್ವ್ ಅಂತ ಮೆನ್ಷನ್ ಮಾಡಿ.
ಓಕೆ,
ಅದೇನು ಪೋಸ್ಟ್ ಆಗ್ತದೆ.
ಬೆಂಚ್ ಕಾಂಬಿನೇಷನ್ ಚೇಂಜ್ ಇದೆ, ಎಂಡ್ ಆಫ್ ದ ಲಿಸ್ಟ್ ಮೂವ್ ಮಾಡೋಕ್ಕಾಗಲ್ಲ.
ಸರ್ವಿಸ್ ಲೇಟ್ ಮಾಡ್ದೇನೆ ಅಲ್ಲ ಏನೇನು
Matter pertains to other bench, my lord. Service
ಯಾವ್ದು?
KAT matter. Fresh matters, my lord. I am requesting to have it on Monday. my lord. So the repatriation matter.
Sorry.
All fresh matters.
All fresh matters. Yes. Mr. Chaudhary, ಏನಿತ್ತು? All right, password. Password ಮಾಡಿ.
Packet of hearings, the
Ah.
process directed.
Password. ಮಧ್ಯಾಹ್ನ ಬೇರೆ ಬೆಂಚ್ ಇದೆ, ಹಂಗಾಗಿ ಬೇಗನೆ ಬರ್ಬೇಕು. All right. Password, yes. Yes.
Senior Counsel Shri S.P. Shankar is, my lord, Senior Counsel Shri S.P. Shankar is injured in his eye, my lord, because of an nasty fall.
He
Kindly
has
grant me.
to text it in. But only thing is, my lords, lordships have heard the matter at length. I'm not, I saw Mr. Shankar. In fact, I spoke to him also. He's had quite a bad injury.
ಅಲ್ಲ,
If
ಅವ್ರದ್ದೆಲ್ಲ
they can
ಆಗಿದೆ
file
activate.
written submissions, ಆಯ್ತಲ್ಲ, ನಾವು written submission ready ಇಟ್ಟಿದ್ದೀವಿ.
ಇಬ್ರು
only
ರಿಟರ್ನ್
not-
ಸಬ್ಮಿಷನ್ ಹಾಕ್ತೀರಾ? ಕೇಳಿ ಶಂಕರ್ ಅವರಿಗೆ ಒಂದು ಫೋನ್ ಮಾಡಿ, ಶಂಕರ್ ಸರಿಗೆ ನಾವು ಕೇಳಿ ನಿಂತು ನಾವು ಕೇಳಿದ್ವಿ, ರಿಟರ್ನ್ ಸಬ್ಮಿಷನ್ಸ್ ಹಾಕ್ಬೋದಾ ಹೇಗೆ ಅಂತ ಅನ್ಕೊಂಡು ಕೇಳಿ, ನೀವು ಅವ್ರು ಹಾಕ್ತೀವಿ ಅನ್ನಂಗಿದ್ರೆ ನಾವು ರಿಸರ್ವ್ ಮಾಡ್ತೇವೆ, ರಿಟರ್ನ್ ಸಬ್ಮಿಷನ್ ಹಾಕ್ತೀವಿ.
Correct, my lord. Only because your lordship has to reconstitute the bench when that will happen. That's the only issue.
ಅದಕ್ಕೆ ಕೇಳ್ಕೊಳ್ಳಿ ಅಷ್ಟೇ, ಮಾಡಿಬಿಟ್ರೆ ಮುಗಿದೋಯ್ತು ಅಲ್ವಾ? ರಿಟರ್ನ್ ಸಬ್ಮಿಷನ್ ಮಾಡಿಬಿಟ್ರೆ ಬಹಳ ಈಸಿ ಇತ್ತ, ಎಲ್ಲ ಅಷ್ಟು ನೋಡ್ಕೊಂಡು ಮಾಡಿಬಿಡ್ಬೋದು. ಹೆಂಗಿದ್ರು ಬಹಳ ರಜಾನೂ ಸಿಗ್ತದೆ ಏಪ್ರಿಲ್ನಲ್ಲಿ. 7-8 ದಿವಸನ ರಜಾ ಇರ್ಬೇಕು ನಮ್ಗೆ. ಕೇಳಿ,
We'll file
ಫೋನ್
as-
ಮಾಡ್ಕೊಂಡು ಕೇಳಿ, ಪ್ಲೀಸ್ ಶಂಕರ್ ಸರ್ ಏನಂತಾರೆ ಕೇಳಿ. ಎಲ್ಲ ಮತ್ತೆ ಸಬ್ಮಿಷನ್ ಮಾಡ್ಲೇಬೇಕು ಅನ್ನಂಗಿದ್ರೆ ಮಾಡ್ಲಿ.
He had finished also, I think,
ಅದೇ
last time.
ಕೇಳ್ಕೊಂಬಂದು. ಪಾಸ್ವರ್ಡ್ ಅಲ್ಲಿ ಯಾರೋ
ಇಲ್ಲ, ಅದು serial number 1, ಅದರಲ್ಲೂ ನಾನೇ ಇದ್ದೀನಿ.
ಹೌದಾ?
I think that serial number 1, it's IA for modification may be rejected, not pressed, my lords.
ಏನದು?
ಇಲ್ಲ, we sought modification, we're not pressing that application.
Faculty, Planet Senior Advocate, Mr. Wilgore submits that his client does not want to press application IA 1 of 2025 and accordingly it be disposed of. First, ordered accordingly.
Grateful.
Your lordship, the seniors engaged in the court hall will not the matter may kindly be passed over.
Passover. All right, Passover. ಉಳಿದವರೆಲ್ಲ ಇದ್ದಾರಾ?
I am ready, Swami. I am for the official liquidator,
Are here.
only contesting respondent ready.
Okay. ಅಲ್ಲಿ ಪಾಸ್ ಅಲ್ಲಿ ಇದೇನು? ಅದು 4ನಲ್ಲಿ ದಿ ಆನರೇಬಲ್ ಹೈಕೋರ್ಟ್ ಆಫ್ ಇಂಡಿಯಾ ಅಂತ ಅನ್ಕೊಂಡು ಪ್ರಿಂಟ್ ಮಾಡಿದ್ದಾರೆ. ಅದು ಆಸ್ಟ್ರೇಲಿಯಾದಲ್ಲಿ ಇದೆ ಅಂತದು, ಹೈಕೋರ್ಟ್ ಆಫ್ ಆಸ್ಟ್ರೇಲಿಯಾ ಅಂತ, ಅಲ್ಲಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್. ಹಿಂಗೂ ಅಲ್ಲ ಹಂಗೂ ಅಲ್ಲ. ಸರಿ ಮಾಡಕ್ ಹೇಳ್ರಿ.
But
Ah.
serial number 7,
ಹಾ
the amicus curiae,
Ah.
Lord, the
ಹಾ
senior
he
counsel,
has met with accident na
morning. It's a
Post
slight
this
injury,
matter on the day when this bench is constituted.
please,
ಅಲ್ವಾ?
slight injury, my lord.
ಹಾ ಗೊತ್ತಾಯ್ತು.
That's,
ಹೌದು.
he has sent
ಏನೋ
for-
ಬಿದ್ದು
Oh, hello, he has sent photo, if my lordship permit me, I will do it to lord.
ಬಹಳ
ಸ್ವಲ್ಪ ಈ ಕಣ್ಣಿಗೆ
ಹಾ. ಎಷ್ಟು ಏಜ್ ಈಗ ಇವರಿಗೆ? ಸುಮಾರು ಹತ್ರ
80
80
82.
82. ಹಾ. ಬೇಗನೆ ಆರಾಮಾಗ್ಲಿ ಅಂತ ಅನ್ಕೊಂಡು ವಿಶ್
ಅದೇ.
ಮಾಡೀವಿ ಅಂತ ಹೇಳಿ. ಅಲ್ಲ ಹಾ ನೆಕ್ಸ್ಟ್ ಸೀಟಿಂಗ್ ಪೋಸ್ಟ್ ಮಾಡ್ಬೇಕು. ಹಾ ಹಾ ವಚನ್ ಏನಾಯ್ತು ಇದರಲ್ಲಿ? ಕಂಪ್ಲೈನ್ಸಾ?
One modification of the order we request, my lords.
ಹಾ.
ಎರಡು ಸೈಟ್ ಕೊಟ್ಟಿತ್ತು, ಒಂದು ವಿಶೇಷ ಲೇಔಟ್, ಕೆಂಪೇಗೌಡ ಲೇಔಟ್.
ಹಾ.
My lord, I'm sorry, my lord, the ಕೆಂಪೇಗೌಡ ಲೇಔಟ್ ಇರತಕ್ಕಂತ ಸೈಟ್ ನ we had already allotted to somebody else. By inadvertence we gave that number. Now, my lord, we are giving another site in ವಿಶೇಷ ಲೇಔಟ್ itself.
ಅಲ್ಲೇ
ಅಲ್ಲೇ ಅವರು ಒಪ್ಕೊಂಡಿದ್ದಾರೆ, ಒಪ್ಕೊಂಡಿದ್ದಾರೆ.
ಒಳ್ಳೇದಾಯ್ತು.
Memo filing with the proceeding sheet as to
ನಿಮ್ ಕ್ಲೈಂಟ್ ಇದಾರ ಇಲ್ಲಿ? ಅವ್ರು ಒಪ್ಪಿದಾರಾ?
ಸ್ವಲ್ಪ ಡಿಫರೆನ್ಸ್ ಅಮೌಂಟ್ ಇದೆ, ಅದನ್ನು ಕೊಡಕ್ಕೆ ಒಪ್ಕೊಂಡಿದ್ದಾರೆ.
ಹಾ.
With suitable modification of the order, my lord, we'll proceed to execute the sale deed.
ಯಾವತ್ತು ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡ್ತೀರಿ?
On the 10 days time ಕೊಟ್ರೆ ಆಯ್ತು.
Yeah.
Within 10 days we will do. Around in all they have to pay around 7,19,320 rupees.
ಹಾ.
The pay
ನಾಳೆ ನಾಡ್ದು ಮಾಡ್ಬಿಟ್ರಿ ಅಮೌಂಟ್. ಬರೋ ವೀಕ್ ನಲ್ಲಿ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಮಾಡ್ಬಿಡಿ.
ಆಯ್ತು.
ಅಟ್ ಲೀಸ್ಟ್ ಇಬ್ರು ಸೇರಿ ಇದು ಹಿಂಗ್ ಕೊಟ್ರಿ ಏನು ಉಪಯೋಗ?
I'm sorry, my lord, I'm sorry, my lord, it's a problem for.
ಮೆಮೊ ರೆಡಿ ಮಾಡ್ರಿ ಇಬ್ರು.
ಹಾ.
ಇನ್ ಟರ್ಮ್ಸ್ ಆಫ್ ದಟ್ ವಿಲ್ ಡಿಸ್ಪೋಸ್ ಆಫ್.
ಅಲ್ಲ ಬೇಡ ಸ್ವಾಮಿ, ಪೆಂಡಿಂಗ್ ಇರ್ಲಿ. We'll comply with it and we'll report it, but
Okay.
we'll comply with it and we'll report it. Otherwise it will unnecessarily lead to other things. I'm sorry, my lord, I'm filing just a proceeding sheet. May I just state it, my lord? My lord, we had agreed to give site number 18. Lordship may kindly come to page 2, my lord, the
ಅಲ್ಲ
proceeding sheet.
ನಮ್ಗೆ ನೀವು ಮೆಮೊ ಬರ್ದು ಕೊಡಿ. ನೀವೇನು ಸಬ್ಮಿಷನ್ ಮಾಡಿ ಎನಿವೇ ಎಲ್ಲ ರೆಕಾರ್ಡ್ ಆಗ್ತದೆ ಹೆಂಗಿದ್ರು.
Please, my lord,
ನೀವೇನ್ ಹೇಳ್ತಾ ಇದೀರಿ ಅದನ್ನ ಬರ್ದು ಕೊಡಿ.
please, my lord.
ಈಗ ಬರ್ದು ಕೊಡಿ. ನೀವೇನ್ ಹೇಳ್ತಾ ಇದೀರಿ,
ಹಾ.
ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಹಿಂಗ್ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀರಿ.
Please.
ನೀವು ಬಾಯಿಂದ ಹೇಳೋದನ್ನ ಲಿಖಿತವಾಗಿ ಕೊಟ್ಬಿಡಿ. ಅದನ್ನ ರಿಫ್ಲೆಕ್ಟ್ ಮಾಡಿಬಿಡ್ತೆ ಆರ್ಡರ್ ನಲ್ಲಿ.
That's why I.
ಕಂಪ್ಲೇಂಟ್ಸ್ ಅಂತಾನೆ ಇಡ್ತೀವಿ.
ಹಾ ಆ ಪ್ರಕಾರ ಮಾಡ್ತೇವೆ ನಾವು. ನೀವೇನು ಸಬ್ಮಿಷನ್ ಮಾಡ್ತೀರಿ,
Please, my lord.
ನೀವೀಗ ಸಬ್ಮಿಷನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಿ. ಎನಿವೇ ಇಟ್ ವಿಲ್ ಬಿ ರೆಕಾರ್ಡೆಡ್ ಹಿಯರ್.
No, I have
ಇದೆಲ್ಲ
no issues,
open
my lord.
ಇದೆ.
No issues with that, my lord.
ಹಂಗಾಗಿ ನೀವು ಹೇಳೋದನ್ನೇ ಇಂಗ್ಲಿಷ್ ನಲ್ಲಿ ಏನು ಓರಲಿ ಹೇಳ್ತಾ ಇದ್ದೀರಿ ಅದನ್ನು ಬರ್ದು ಕೊಡಿ.
Please, my lord. I have no difficulty, my lord, I'll do it. But why I place the proceeding sheet is that this change in site number has been approved by the
ಅದನ್ನು
commission.
ಬರ್ದು ಕೊಡಿ.
Please, my lord. Please.
ಅದನ್ನು ಬರ್ದು ಕೊಡಿ.
Please, my lord.
ಯಾಕಂದ್ರೆ ಸೆಟಲ್ಮೆಂಟ್ ಆಗಿದೆ ಅದಕ್ಕೆ. ಅದರ್ವೈಸ್ ಆರ್ಗ್ಯುಮೆಂಟಿಗೆ ಬಿಡ್ತಿದ್ವಿ.
ಇಲ್ಲ, ನಾನು what I am trying to suggest, my lord, is this. In the directions of this honorable court is to give me two sites, to give them two sites based upon the affidavit that I filed, my lord. In which I am unable to give one site. It was my mistake. They gave the wrong site number.
ನೋ ಇಶ್ಯೂ. ಈಗ ಅವ್ರಿಗೆ
Modification of the order, if your lordship may kindly grant modification of the order and keep the matter pending, my lord.
ಅದನ್ನೇ ಬರ್ದು ಕೊಡಿ.
Please, my lord.
ಹಂಗೆ ಬರ್ದು ಕೊಡಿ.
Please. Please.
ಹೊರಪೇ ಟೀಮ್ ಕೊಡಿ.
ಮಾಡಿಫೈ ಮಾಡಿ ಈ ಕಾರಣಕ್ಕೆ ಅಂತಾನೆ ಬರ್ಕೊಡಿ.
ಬರ್ದು ಕೊಡಿ. ನಾವು ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳ್ಬಿಡ್ತೀವಿ. ಯಾಕಂದ್ರೆ ಒಪ್ಪಿದ್ದಾರೆ ಅಂದ್ರೆ.
In all correctness, my lord, it has to come on an affidavit of a commissioner because the earlier affidavit was by the commissioner.
ನೀವು ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ರಾ?
ನಾನು ಮಾಡಿದ್ದೀನಿ ಸ್ವಾಮಿ. On the
ಇಲ್ಲಿ ರೆಕಾರ್ಡ್ ಇದನ್ನ ಯಾರು ಬೇಕಾದ್ರೂ ಅಪ್ಲೋಡ್ ಮಾಡಿ, ಇದು ಡೌನ್ಲೋಡ್ ಮಾಡಿ.
proceeding sheet basis ಮೇಲೆ ಮಾಡಿದ್ದೀನಿ ಸ್ವಾಮಿ.
ಇದು ನೀವೇನ್ ಹೇಳಿದ್ರಿ ಅದನ್ನು ಬರ್ದು ಕೊಡಿ.
ಆಯ್ತು, ಕೊಡ್ತೀನಿ ಸ್ವಾಮಿ.
ಟೈಮ್ ವೇಸ್ಟ್ ಆಗಲ್ಲ, ನಿಮ್ದು ಆಗಲ್ಲ, ನಮ್ದು ಆಗಲ್ಲ. ಆಮೇಲೆ ನಾವು ಹಂಗೆ ಹೇಳಿಲ್ಲ, ನೀವು ಹಿಂಗೆ ಹೇಳಿಲ್ಲ, ಇವೆಲ್ಲ ಬೇಡೇ ಬೇಡ.
ಆಯ್ತು.
ನೀವೇನ್ ಹೇಳ್ತೀರಿ ಬರ್ದು ಕೊಡಿ.
Please, madam.
ಅವ್ರಿಗೆ ಒಂದು ಕಾಪಿ ಕೊಟ್ಟು ಪಾಸ್ ಓವರ್.
Please, madam.
ಅವ್ರನ್ನೂ ಕಾನ್ಫಿಡೆನ್ಸ್ ನಲ್ಲಿ ತೊಗೊಂಡೆ ಬರ್ದು ಬಿಡಿ. ಸೊ ದಟ್ ಇಟ್ ಬಿಕಮ್ಸ್ ಈಸಿ. ಆ ಪ್ರಕಾರ ಆಗಿ ಹೋಗ್ಬಿಡುತ್ತೆ. ಓಕೆ. ಅದು ಎಕ್ಸಿಕ್ಯೂಷನ್ ಆಗೋವರೆಗೆ ಇಡೋಣಂತೆ. ನೀವು ಸೇಲ್ ಡೀಡ್ ಯಾವತ್ತು ಮಾಡಿ ಕೊಡ್ತೀರಿ ಅವತ್ತು ಕ್ಲೋಸ್, ಅಲ್ಲಿ ತನಕ ಕ್ಲೋಸ್ ಮಾಡಲ್ಲ ನಾವು.
Please, my lord.
ಮತ್ತೆ ಅದಕ್ಕೆ ಒಂದು ಕಂಟೆಂಪ್ಟ್, ಅದಕ್ಕೆ 7 ವರ್ಷ.
Oblige, oblige.
ಬರೀ ಅದನ್ನ ಮಾಡ್ಬೇಕು ಜೀವನ ತುಂಬಾ.
For the respondent.
ಹಾ,
But in this matter, my lord, I had earlier argued the lord, showing your lordships, the division bench order passed by the division bench of this honorable court.
ಕರೆಕ್ಟ್.
Lord, subsequently, my lord, I have also filed, I have also filed a memo. Lord, here is the contention, one of the contentions which was raised by the.
Good. ಕೊಡ್ತಾಯಿ ಮತ್ತೆ ಕರೀತು ಕೊಡು.
One of the contentions which was raised by the learned senior advocate appearing for the petitioner was that.
ಹೊಳ್ಳ್ರು ಮಿಸ್ಟರ್ ಹೊಳ್ಳ.
Yes. Was that the petitioner, the landowners were all throughout represented by their power of attorney holder, that's a Tata Housing Limited, before the learned single judge and the honorable division bench on a previous round of litigations. Lord, may I request your lordships to, Lord, I pointed it out on the earlier occasion.
ನಿಮ್ಗೆ ಯಾಕೆ ಟೈಮ್ ಕೊಟ್ಟಿದ್ವಿ ನಾವು? ವೈ ವಿ ಹ್ಯಾಡ್ ಗಿವನ್ ಟೈಮ್ ಟು ಯು?
Lord, on that day, Lord, I was unable to conclude because I had to read the judgments and show your lordship certain documents.
Yes.
And other aspects, is, your lordships had directed me to show that the subject matter writ petition survey numbers were not part of the Lord, the earlier resolutions. Yes. Prior to that, or on that day, Lord, I had filed an affidavit. Your lordships had looked into that affidavit filed by the BDA, and Lord, the subject lands were not a part of Lord, either the 2013 resolution, 14 resolution, or 2011 resolution.
Yes.
Lord, all these three, what has been read by the learned senior counsel with regard to the proceeding sheets which were maintained by the BDA, Lord, in which these three resolutions were referred to by the then commissioner, Lord, while referring the matter for proper adjudication before the state government.
Correct.
Those three, Lord, I have two. One was placed by the learned senior petitioners itself. Two I have placed, in which, Lord, these survey numbers do not find a part. Now, Lord, what was contended is the petitioners who were the landowners, Lord, were all together challenging the acquisition proceedings before the learned single judge and the honorable division bench with regard to Arkavati layout. Lord, in my respectful submission, Lord, that is, Lord, may not be a correct position because, Lord, I have filed. Lord, lordship may kindly take, Lord, the memo of judgment which I had filed, Lord.
Yes.
And Lord, in this, Lord, specifically, the honorable court has dealt with the issue, Lord.
Yes.
Lordship may kindly take page 177, Lord, of this memo.
Yes. 5 names are there. Come to
Yes.
177.
Yes, and
Yes.
the petitioner was, Lord, the Tata Housing.
Yes.
The petitioner in that writ petition was Tata Housing and not these petitions.
Correct.
Yes, and before the honorable division bench also, not the same issue.
Yes.
But what the liberty was reserved by the division bench of this honorable court was to the Tata Housing Limited to approach the BDA
Yeah.
for deletion of the land on the premise that the state had.
Come to page 19, para 95, page 292.
Please,
Read.
yes, para 95. Lord, prior to it, Lord, may I read, Lord, para 91 or 91?
Yes. Facts in WP number 258570.
Yes.
You read that other day,
Yes,
therefore,
yes,
anyway,
yes.
you can read again.
I'm sorry.
ನೀವು ಓದಿದ್ಮೇಲೆ ನಾವು ನೋಟ್ಸ್
Yes,
ಮಾಡ್ಕೊಂಡಿದ್ವಿ.
And para 93, Lord.
93.
Yes. in view of the aforesaid law,
Yes.
in view of the aforesaid law, it is clear the government is not exempt from liability to carry out the representations made by it as its future conduct. A clear and unequivocal promise, knowing and intending that it would be acted upon by the promise and such.
It speaks of promissory estoppel.
Promissory estoppel.
Yes.
Then, Lord, Lordship may kindly take, Lord, 95, Lord, para 95.
Yes.
However, in WP number 25807 of 2000.
94 once Odi.
Please, sorry,
Because 93
in the global meet.
and 94
Yes,
are cognate paragraphs.
Please.
Yes.
in the global meet, the government made a promise to all the investors to invest in Karnataka, and they would provide the necessary infrastructure such as land, power, water supply, and other concessions and incentives. Acting on the said representation, the first petitioner made a request for 53 acres of the land, to set up an IT park. High power committee constituted by the government, which includes the departmental heads, passed an order granting a request made by the petitioners. Thereafter, this is not pertaining to these petitioners, this is pertaining to another petitioner.
Companion petition.
Yes, Lord, which was also allowed, and Supreme Court, Lord, has set aside this portion of the acquisition proceedings.
Yes.
Lord, I'll read, Lord. Thereafter, the KIDB was directed to identify the lands to meet the requirements of the petitioner. In the meanwhile, the petitioners negotiated with the owners of the land with a full knowledge of the government, paid consideration, purchased the land with a fond hope of immediately starting the project by avoiding litigation and delay. In the meanwhile, KIDB also identified the lands. When the impugned notifications were issued, notifying the acquisition of the lands purchased by the petitioners as well as the lands by the KIDB for the petitioners, KIDB wrote to the BDA, who is a party to the government order, to drop the acquisition proceedings. Petitioners also filed a detailed objection to the proposed acquisition. BDA had the jurisdiction not to acquire the land, as they have given up the acquisition of the land to an extent of 580 acres of the lands notified in the preliminary notification. Even though they did not uphold the objections of the petitioners and submit the scheme for approval before the government had jurisdiction to refuse to acquire the land of the petitioners in view of the government order and the promise made by them. They also did not act promptly. The aforesaid facts make it clear that the petitioners have altered their position, spent huge amount of in acquiring the land and making other preparations on the representation of the government, which is in writing and evidenced by the government order. Before the court, they neither pleaded nor placed any material to show the overriding public interest, which compels them not to honor the promise. In law, there was no prohibition to delete the said lands from acquisition. On the contrary, the government had jurisdiction to give up the acquisition. Therefore, all conditions requisite for the application of the doctrine of promissory estoppel are established, and the acquisition of the lands purchased by the petitioners and intended for them is hit by the doctrine of promissory estoppel. In view of the discussions made above, the finding of the learned single judge that the plea of estoppel is not available against the state is not correct. Consequently, the acquisition of lands in respect of the first petitioner has already what the first petitioner has already purchased and what is proposed by the KIDB for the first petitioner is accordingly quashed. Then, Lord, the next paragraph, Lord, this is
25807 of 2004.
Yes, with regard to the petition lands, petition scheduled properties. However, in WP number so and so, material on record is not sufficient to grant the relief sought for. Firstly, the petitioners are only agreement holders. Though there is an award in their favor, the same is under challenge. Secondly, the agreement is held to be invalid under the provisions of the Karnataka Land Reforms Act, and the said order is also under challenge in appeal. Thirdly, the
What happened to that appeal?
Lord, that appeal, Lord, the Tata Housing withdrew it.
Withdrew that.
Yes,
How agreement to purchase, buy
yes.
agriculture land would be violative of 79 AB then as it then was? Then
Lord, there are the proceedings, Lord, which have been held, which I have produced it along with the memo, Lord. This was not initiated by the government. But these proceedings were ironically initiated by the petitioners' landowners against the Tata Housing. But there was an admittedly, what was not the understanding between the Tata Housing and the petitioner, as per their agreement, what it shows is, there was no land sharing. There was only the proceeds of the
Sale
sales were to
proceeds
be.
of
Yes.
structures.
Yes, were to be shared by the petitioner and the Tata Housing. But in spite of that, they go and approach the Assistant Commissioner to initiate proceedings under 79A and B and 80.
No, that's only just we wanted to know.
Yes.
How agreement to buy a land is violative of 79A
Sorry.
and B.
Yes,
It
no,
is acquisition of that land by sale deed.
it was virtually a sale.
Mortgage, lease,
Yes.
etc.
It was virtually a sale deed. There's an award by the three, the arbitration award was passed by the three Supreme Court judges. And my lord, that was under challenge and there was an interstate dispute between them. During the pendency, my lord, they come before this honorable court and say, the landowners, they come before this honorable court and say, we are agreeable for acquisition, we want compensation. Lord, that is recorded by this honorable court. That is why that entire prayer was not allowed, because the landowners came and said they want compensation. And
Okay.
Tata Housing, Lord, wanted to retain the land.
Yes.
Though there is an award, sorry. Secondly, the said agreement is held to be invalid under the provisions of the Karnataka Land Reforms Act, and the said order is also under challenge in appeal. Thirdly, the landowners are contesting the
So
claim of the
the
petitioner.
order holding agreement to be void
Yes,
remained.
remained. And my lord, it was set aside only in the year 2021. Not in 2013. As on the date,
It
when-
was there.
yes, as on 2013, when they say that they have a resolution in their favor for deletion of the land, as on that day, they did not have an exclusive right over the property.
Yes.
This is my, yes, please. Thirdly, the landowners are contesting the claim of the petitioners. And in fact, they have filed a memo before this honorable court stating that they have no objection for the acquisition. Landowners are the present petition. Yes. Though not much credence can be given to the said memo, still the title of the petitioner is to be established. Under these circumstances, the proper course would be to direct the petitioner to approach the BDA with an application setting out their claim, and the BDA shall decide the said claim on merits in the light of what we have said above. If the BDA were to uphold the claim of the petitioners, then the lands covered in this writ petition would stand excluded from acquisition. If the claim is negated, the landowners have no objection for acquisition. The acquisition of the land stands affirmed, and the BDA would be at liberty to form the layout in the land as a part of our Kavati layout. Till such adjudication, the BDA shall stay its hands.
Yes.
Yes, but then, Lord, they themselves had acquiesced to the acquisition proceedings and came before this honorable court to say, we are ready to give the land, want compensation. Lord, this finding of the honorable division bench has attained finality.
Now,
Pursuant
the
to this-
resolutions which you disputed,
Yes,
they are of which year?
Lord, of 2013, 2011, 13 and 14. Lord, may I, Lord, one affidavit is filed on Lord 10th December 2024 with regard to Lord Resolution 79 of
So
2013.
that is subsequent to this judgment.
Yes,
What the resolution say?
resolution, in this resolution, there is no discussion. This point had not been discussed by the BDA or recommended for the state government for deletion. This is not, this doesn't find a place in 79 of 2013.
No, one particular resolution you have shown
Yes.
the other day, which is that resolution?
Lord should make,
Huh?
yes.
Page
I have-
57.
Yes. 57 of 11. Resolution number 57 of 2011.
Page number?
Lord, Lordship may kindly take my memo, Lord, page 96.
Page number 137 of my,
Of appeal.
is Annexure K, my lord.
Petition 130.
Page 137 internal page, Annexure K.
But
Mark
this
is
is-
Annexure K.
This is a proceeding sheet. But this is a proceeding sheet, Lord.
Yes,
I have produced the resolution only, Lord, at page 137. Sorry, at page 96.
This is proceeding sheet resulting into resolution.
No, Lord.
No, it reflects what is the resolution.
This
Yes,
is a
my lord.
proceeding sheet written by the commissioner himself saying that these proceedings are as per resolution number 57/11, 39 of 2013. That's why Lord, the committee finds a fault with it. There's no such resolution. That is what is the committee observes. Lordship may kindly take my memo, page 96, Lord. I produced the resolution and the
96 of your memo,
yes,
affidavit of memo, no?
memo, Lord. Memo producing documents. 31st January 2025.
September.
Yes, page 96.
25/11.
96, Lord, last annex page. This is the resolution 57/2011.
Which bears signature of Honorable Chief Minister.
No, this is not that.
There is one order, na?
Lord, that is the memo which they had filed.
Huh.
Lord, I had filed it on 31st January 2025. Page 96. Six. Here. Sir. Ade.
155.
Section H.
Done it. Memo along with documents.
Where pass?
12/3.
Where?
Okay. You are right.
Please.
Ah,
Not, this is the resolution 57 of
96.
page 96, not. This is the resolution 57 of 2011. May I read, Lord?
Ah, okay.
Please. ಅರ್ಕಾವತಿ ಬಡಾವಣೆ ನಿರ್ಮಿಸಲು ಭೂಸ್ವಾಧೀನಪಡಿಸಿಕೊಳ್ಳಲಾದ ಪ್ರತಿ ಎಕರೆ ಜಮೀನಿಗೆ 45ರಷ್ಟು ಅಭಿವೃದ್ಧಿ ಪಡಿಸಿ ರಸ್ತೆ ನಾಗರಿಕ ಸೌಲಭ್ಯ ಮೀಸಲಿಟ್ಟು ಉಳಿಕೆ 55% ವಸತಿ ನಿವೇಶನಗಳನ್ನಾಗಿ ವಿಂಗಡಿಸಿ ಪ್ರತಿ ಎಕರೆಗೆ 60-40 ಅನುಪಾತದನ್ವಯ ಭೂ ಮಾಲೀಕರಿಗೆ ಶೇಕಡ 40 ಅಂದರೆ ಪ್ರತಿ ಎಕರೆಗೆ 9,573 ಚದರ ಅಡಿ ಅಭಿವೃದ್ಧಿ ಪಡಿಸಿದ ನಿವೇಶನ
60-40 ratio. This says what? Then
this is with regard to compensation. What was resolved in 57/2011.
15/2011. That resolution which the commissioner referred to.
Refers to is this resolution. Lord, that is why the committee finds a fault with the so-called recommendation sent. In 39/2013 it is not there. In 57/2011 it is not there. But do you refer these resolution and send it for deletion to the state government?
But Honorable Chief Minister also had looked into all this.
Yes, Honorable Chief Minister had looked into. Lord, that is why this Honorable Court Lordship Justice Arvind Kumar, while constituting a committee, takes note of such things. Lordship may permit, I'll read out such observations by the learned single judge, Lord, and says that even though they were not eligible, even though there were no facts available, such a recommendations are made. That is why I don't have a faith in the adjudication made by the BD and the state government. That is why a constitution of a committee has become very necessary. That is why I constitute a committee to look into all these such recommendations of a 983 acres under which these deletions have taken place.
What the committee says on the participation of the Chief Minister himself in the proceedings?
But committee doesn't talk about the participation of the chief. But
If we do not repose confidence in what the Chief Minister is saying, he is Chief Executive of the state.
Lord, may I make a request for Lordships?
What is your contention on that? What is your stand before the learned single judge about the government's deliberation. That amounts to saying, we should not believe the proceedings that bear the signature of the chief minister unless you dispute signature itself is, forged or fabricated, we can understand.
Or may I make one submission? May I make one submission? Not in 2014, Lord. In 2014, the government itself constitutes a committee. By the retired judge of this honorable court to look into all such illegalities. That report.
What the committee said about
Not-
illegality of chief minister's proceeding?
Lord, that has not, the report has been sent to the state government. It is still not tabled. Arkavati committee.
We are asking.
Yes.
If the proceedings drawn by the principal secretaries, recommendation by the chief secretary, honorable chief minister has put his signature,
Yes.
even that should not be believed by us,
Not.
whichever be the party.
Yes.
He is
No.
our chief minister,
Yes.
chief minister of the state.
Yes. Lord, I cannot argue anything contrary to it with the fact that, Lord, may I request, the lordship may kindly take the order passed by.
But he is our chief minister ಅಂದಾಗನೆ ಮತ್ತೆ ನಾಳೆ ಪೇಪರ್ನಾಗೆಲ್ಲ ಅದನ್ನ ಆ ರೀತಿ ಹಾಕೊಂಡ್ರಿ. Our chief minister means he is chief
State.
minister, elected chief
Elected.
minister of our state ಅನ್ನೋ ಅರ್ಥದಲ್ಲಿ.
Yes.
ಅದನ್ನೆಲ್ಲ ಹೇಳ್ಬೇಕು ನಾವೀಗ. ನಾವು ಮೊನ್ನೆ KPSC ದಲ್ಲಿ ಅಟ್ಲೀಸ್ಟ್ 50% ಆದ್ರೂ ಕೊಡಬಾರ್ದು ಅಂತಂದ್ರೆ ಇನ್ನ 50% ಕರಪ್ಷನ್ ಮಾಡಿಬೋದಾ ಅಂತ ಹೇಳ್ದಂಗೆ ಆಗ್ತದೆ ಅಂತ ಯಾರೋ ಒಬ್ರು ಕೇಳಿದ್ರು. ನಾವು ಏನೋ ಒಂದು ಸಟೈರ್ ಆಗಿ ನಾವು ಹೇಳಿರ್ತೇವೆ. ಅದನ್ನ ಆ ರೀತಿ ಎಲ್ಲ ಇಂಟರ್ಪ್ರಿಟ್ ಮಾಡ್ಕೊತ ಹೋದ್ರೆ ಅದಕ್ಕೆ ಸ್ವಲ್ಪ ಅದನ್ನು ನಾವು ಕೇಳ್ತಾ ಇರೋದು, he is our chief minister means he is chief minister of our state.
Yes.
And elected chief minister. ಎಲ್ಲ ಹಾಗೆ ರಿಸರ್ವ್ ಮಾಡ್ಕೊಂಡು ಬಂದು ಕೂತ್ಕೊಂಡು ಚೀಫ್ ಮಿನಿಸ್ಟರ್ ಅದೇ ಕರ್ನಲ್ ರಬುಕಾ ಮಾಡ್ದಂಗೆ ಆಗಿದ್ರು ಘಾನದಲ್ಲಿ ಆದಂಗಾದ್ರೆ we can understand.
Yes.
He is elected representative of the people,
In,
whoever be he.
Lord, in my respectful submission is,
ಅದ್ರ ಮೇಲೆ ಎಲ್ಲಿದೆ what the committee has said?
committee has said against the officials of the person, officials.
Why not against the chief minister?
Kindly, lordship may permit me, why is not said? Lordship may kindly take, page 70, Lord, I'm sorry, Lord, in the very same, this one. Lord, lordship may kindly take page 53, Lord, of the same memo. 53, say no. Lord, this Anopacharika tippani. Lord, in the memo which I was referring, Lord, earlier. Lord, not that, that is an affidavit.
Advice.
That is an affidavit. Your lordship, you are just reading that,
Memo.
yes. Resolution 57/2011, same, Lord, may I pass out for convenience? One more. copy.
ಮತ್ತೊಂದು 1.
96 ಅಂತ ಹೇಳಿದ್ರಲ್ಲ ಅದ ಸೆಕೆಂಡ್ ಪಾರ್ಟ್ ಕೆಳಗೆ ಅದಕ್ಕೆ ರಿಟ್ ಪ್ರೊಸೀಡಿಂಗ್ ರೂಲ್ಸ್ ನಲ್ಲಿ ಅದ್ ನಾವ್ ಹೆಂಗ್ ಮಾಡ್ಯಾರ ಅಂದ್ರೆ ಅದು 77 ಮಾಡಿದ್ದು ಅದೆಲ್ಲ ಆ ಟೈಮ್ನಲ್ಲಿ ಮಾಡಿದ್ದೆಲ್ಲ ಅವ್ರೇನ್ ಮಾಡ್ಯಾರ ಅಂದ್ರೆ ಪಿಟಿಷನ್, ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್, ರಿಪ್ಲೈ ಸ್ಟೇಟ್ಮೆಂಟ್, ಮೂರೇ. ಇದು ಹಿಂಗೆಲ್ಲ ಹಾಕೋತ ಹೋದ್ರೆ ನಮ್ಗೆ ಹೆಂಗ ಬೇರೆ ಯಾವ್ದನ್ನ ಎಲ್ಲಿ ತಗೋಬೇಕು ಅಂತಾನೆ ಗೊತ್ತಾಗಲ್ಲ. ಆಮೇಲೆ ಕೌಂಟರ್ ಇರೋದು ವಿತ್ ಲೀವ್ ಆಫ್ ದ ಕೋರ್ಟ್ ಅಷ್ಟು ಬಿಟ್ಕೊಂಡ್ರೆ ಬೇರೆ ಹಾಕ್ಲಿಕ್ಕೆ ಬರಂಗೇ ಇರ್ಲಿಲ್ಲ. ನೀವು ಇಷ್ಟು ಮಾಡಿದ್ರೆ ಹೆಂಗ ನಾವ್ ಹೆಂಗ್ ನೋಡ್ಕೋಬೇಕು? ಪೇಜ್ ನಂಬರ್
53. But the special land acquisition officer, Lord.
ಅನೌಪಚಾರಿಕ ಟಿಪ್ಪಣಿ.
Yes, ma'am. On 15/12/2012, a report was called for by the land acquisition officer with regard to the very same survey numbers. Not 17/1, 18, 19, 20, 26, and 94 of Hennur village. A report was called for. Lord, may kindly take page 54, Lord. What was the report that the engineering section had submitted? Lord, may kindly see, Lord. ಕೆಳಗಡೆ ನಿವೇಶನಗಳ ಸಂಖ್ಯೆ, ಸರ್ವೆ ನಂಬರ್, ನಿವೇಶನಗಳ ಸಂಖ್ಯೆ, ರಚಿಸಲಾಗಿರುವ ನಿವೇಶನಗಳ ಸಂಖ್ಯೆ, ಒಟ್ಟು ನಿವೇಶನಗಳ ಸಂಖ್ಯೆ. Lot may kindly see, my lord, 205 sites were already formed. This is a report by the estate executive engineer. Lot may kindly take, my lord, next, my lord,
Is it prior to chief minister's proceeding or
yes.
after?
prior to chief minister's proceeding.
ಮತ್ತೆ ನಾನು
But
ನೋಡಿದಾಗ
why I'm making this submission is the recommendation which was sent was not in terms of the records.
No, how,
Not
who are
to
we to
say.
say this? When the, what is the role of the chief minister under the BDA Act? Sorry, BDA Act, ಕೊಡಿ.
Lord, and the chief minister, it's a state government's, lord, a supervisory jurisdiction under section 65. Now, what happens is,
No,
But-
no.
no chief minister,
ಯಾವ ಮಿನಿಸ್ಟರ್ ಇರಲ್ವಾ?
ಇಲ್ಲ, ಯಾವ minister?
BDA ದಲ್ಲಿ ಯಾವ
ಇಲ್ಲ,
ಮಿನಿಸ್ಟರ್?
yeah.
ಸೆಕ್ರೆಟರಿ ಇದೆ.
BDA ಗೆ commissioner and secretary.
No, BDA comprises of, board comprises of.
Board
whom?
comprises, please.
AIDB chief minister,
ಹೌದು. Lord, section 3, lord,
ಹಾ.
may I read, lord? The authority shall consist of the following members, namely the chairman. Please. The authority shall consist of the following members, namely the chairman,
finance member,
finance member, engineering
Engineer.
member,
town planner,
town planner, a person with an experience in architecture, the commissioner, the officer of the secretariat department in charge of urban development and not below the rank of deputy secretary to the government. 2 persons who are the members of the Karnataka state legislature, 2 persons with of whom one shall be a woman and one shall be a person belonging to scheduled caste and scheduled tribes. 4 others to whom one shall be represent the labor, a representative of the BWSSB, KEB, not KSRTC, 2 persons elected by the councillors of the Bangalore City Corporation from among themselves to prescribe manner.
all.
The commissioner.
This is what the board comprises of.
Yes,
Then matter goes to the government under which section?
but the matter goes to section 65.
Read.
Government's power to give direction to the authority. The government may give such directions to the authority as in its opinion are necessary for expedient for carrying out the purpose of this act. And it shall be the duty of
Duty of the authority to comply
with
such
such
directions. Government means chief minister. We have held in that Sudhindra Rao versus state of Karnataka.
Yes,
We have held state chief minister is also part of the government ಅಂತ hold ಮಾಡೇವೆ ನಾವು.
yes,
And it is affirmed by the Supreme Court.
but it is only the power of the government is not for the day-to-day affairs. The power is only restricted to the government may give such direction to the authority and as its opinion.
Did you take
necessary-
up that stand before the committee?
But we are not.
Then you cannot take up. on
But
that.
there's a context, the committee.
That, how to, we are only saying this.
Yes.
Though we have not, accepted Raja Pratyaksha Devataha, but the Honorable Supreme Court has said, Chief Minister is the executive head of the government of the day. And all decisions by all ministries can be taken by the Chief Minister under the transaction of business rules, allocation of business rules.
Yes.
Any decision of any ministry,
He has.
Chief Minister can take that decision.
But
That's how
yes,
Parikar judgment.
Yes.
Therefore, here is an order of the, that's what we are saying. You do not take a stand against the order signed by the Honorable Chief Minister and so many secretary, etc. Before the committee. You should have said, the Honorable Chief Minister, we can, this is, you perhaps you are, this is not brought to your notice. Kindly look into this.
But-
Any information, any interaction
Yes.
has to happen.
but may I make.
How to discredit? ಈಗ ನಿಮ್ಗೇನೋ
I'm-
ಚಿಕ್ಕದು ಕಾಣ್ತದೆ ಅದು. ಒಬ್ಬ ಒಂದು ಚೀಫ್ ಮಿನಿಸ್ಟರ್ ಮಾಡಿದಂತ ಆರ್ಡರ್ ಅನ್ನ
Please.
you cannot be more loyal than the king.
Yes,
King
can-
is the
Lord.
loyalty incarnate.
Yes.
And subject cannot be, or his institutions cannot be more loyal than the king himself. English nalli yado ಒಂದು principle ಇದೆ. He was more loyal than the king himself.
Yes.
It cannot be like that. It is only a satire. Adra.
Yes.
Sartre. That's another thing. We are saying you do not find fault with the proceedings of the Honorable Chief Minister, right or wrong. It may be wrong, but it is our Chief Minister's order. Do you agree that the BDA is at least subordinate to the government?
Please,
You agree?
I am. Yes. But
And you agree that the government is headed by the Chief Minister under our constitutional scheme?
Yes.
You also agree with that?
Yes.
And the Chief Minister has taken a decision.
Yes.
It may be a wrong decision.
Yes.
If we consider his approval as a direction to you, where are you under section 65? You did not bring it to the notice of the chief
Well,
minister that it is wrong.
No, my lord.
You
Lord,
didn't take up that
no, my
stand.
lord, we have not.
And
taken-
then chief minister
Not only
approved it. It was only your business to carry out that direction.
Yes, my lord.
That's all.
Not only in respect of the petition scheduled properties, but too in respect of 983 acres.
And we do not know.
No, no, may I make the
But-
submission. Why? Because
You are it virtually permitting you to say this is to discredit the proceedings of the Chief Minister. That we will not take.
no, I am not.
It
doing-
may be very wrong, etc. But many things, see what in Ramayana you have seen. Rama was asked by people, your king, ನಿಮ್ಮ ಅಪ್ಪಗೆ ಅವನ ಮೂರನೇ ಹೆಂಡತಿ ಮೇಲೆ ತುಂಬಾ ವ್ಯಾಮೋಹದಿಂದ ಇದನ್ನ ಹೇಳಿದಾನೆ, ನೀನು ಹೋಗ್ಬೇಡ ಅಂತ ಅನ್ಕೊಂಡು ಹೇಳಿದ್ರೆ, ರಾಮ ಸೇಸ್, ಬೇರೆ ಅಪ್ಪ ಅಲ್ಲ, he is king of Ayodhya kingdom. If his sons do not obey the king, how subjects will obey? Therefore, I have to go. It may be right, wrong, it's not my business. King has said, I will. He is my Pitru. Pitru Vakya Paripalanartha. This is how Valmiki writes.
Yes.
He is my father.
Father.
I cannot challenge his wisdom. He is king. I have no right to challenge his decision. Simply I will follow.
Yes.
That is how our constitution is also modeled.
Yes.
That's the reason why you find Ramayana pictures in the original constitution,
Yes.
not for child's
Yeah,
play.
yes.
Ankalipili iruvanta chitra, ಒಂಟೆ ಆನೆ ಚಿತ್ರ alladu. They want to give some value, the ancient values with which constitution is animated. This is what Paili, M.E. Paili writes. And B.N. Rao said, that's how it there, the ಚಂದ್ ಕಾಣ್ಲಿ ಪುಟ ಅನ್ನೋದಕ್ಕೆ ಮಾಡಿದಂತ ಚಿತ್ರಗಳಲ್ಲ. ಅದಕ್ಕೊಂದು ದೊಡ್ಡ 9-member ಕಮಿಟಿ ಮಾಡಿ ಇಂತಿಂತ ಚಿತ್ರಗಳನ್ನು ಇಂತಿಂತ ಚಾಪ್ಟರಿಗೆ ಹಾಕ್ಬೇಕು ಅನ್ಕೊಂಡು ಡಾಕ್ಟರ್ ಅಂಬೇಡ್ಕರ್ದು ಅಪ್ರೂವಲ್ ತಗೊಂಡು ಆಮೇಲೆ ಹಾಕಿದಂತ ಚಿತ್ರಗಳು. ಅದು ಅಂಕಲಿಪಿಯಲ್ಲಿರೋ ನೋಡಕ್ ಚಂದ್ ಕಾಣ್ಲಿ ಅನ್ಕೊಂಡು ಹಾಕ್ತಾ ಕ್ಯಾಲೆಂಡರ್ ಚಿತ್ರಗಳಲ್ಲವು. These are the finer aspects of the.
Yes, not as a BDM, Lord, I have not gone against the decision of the state government, not pursuant to this decision of the Honorable Chief Minister or the state government. A modified scheme of Arkavati layout was published in the year 2014. All these exercises have taken place in 2012, 13, and 14, pursuant to the order passed by the Honorable Supreme Court of India. 2014 is the revised scheme of formation of Arkavati layout was published. It is as per the decision of the state government. Not 2014 was a notification. Those 2014 notification were challenged before this honorable court. Lord. May I request your lordship to kindly take the order.
What is the order dated, the proceedings of Honorable Chief Minister?
27/3/2014, madam.
27/3,
2014.
2004, which is that page
Lordship may kindly take page 92, Lord,
of your memo?
of their memo. 70.
Memo.
Please,
ನಿಮ್ದೊಂದು ಮೆಮೊ ಇದೆಯಾ?
ಇಲ್ಲಿ ಅವ್ರು ಈ ತರದ್ದು. Okay, ಅಲ್ಲೇ.
I have given two compilations. One was filed on 22/11.
ನಿಮ್ಮ ಪೇಪರ್ ಬುಕ್ ಅದ ಪೇಜ್ ಏನು?
That is, this proceedings is in the separate memo, so paper book al hakilla adu. It is filed on 22/11/2024.
22/11.
Page. The Honorable Chief Minister did not approve this one particular, this one. May kindly take page 80.
75 money. Page 75 money.
Please,
74 even.
74.
Hmm.
Please. Prastav, 364,
364.
ಪ್ಲೀಸ್. ಪ್ರಸ್ತಾವನೆಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ವಿವರಗಳನ್ನು ಖಂಡಿಕೆ 355ರಿಂದ 366ರವರೆಗೆ
63ರವರೆಗೆ.
ಸಾರಿ 63ರವರೆಗೆ ಹಾಗೂ ಪ್ರಾಧಿಕಾರದ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಪುಟ 960ರಿಂದ 925 ನೋಡಬಹುದು. ಆಯುಕ್ತರು ಬಿಡಿಎ ಅವರು
ಪ್ರಸ್ತಾಪಿಸಿರುವ
ಅರ್ಕಾವತಿ ಬಡಾವಣೆಯ ಪರಿಷ್ಕೃತ ಯೋಜನೆ ಮಾಡಿಫೈಡ್ ಸ್ಕೀಮ್ ಅನುಷ್ಠಾನಗೊಳಿಸುವ ಬಗ್ಗೆ ಖಂಡಿಕೆ 361ರ ಮೇಲೆ ಮಾನ್ಯ
ಮುಖ್ಯಮಂತ್ರಿಯವರ
ಆದೇಶ
ಆದೇಶ
ಕೋರಬಹುದು.
ಕೋರಬಹುದು. That was the note which they had put. Come to
Yes.
then next. ಅರ್ಕಾವತಿ ಪರಿಷ್ಕೃತ ಯೋಜನೆಯ
ಪ್ಲೀಸ್. ಅರ್ಕಾವತಿ ಪರಿಷ್ಕೃತ ಯೋಜನೆಯ ಪ್ರಸ್ತಾವನೆಗೆ ಸಂಬಂಧಿಸಿದ ವಿವರಗಳನ್ನು ಖಂಡಿಕೆ 355ರಿಂದ 364ರವರೆಗೆ ಹಾಗೂ ಪುಟ 960ರಿಂದ 925ರವರೆಗೆ ಪ್ರಾಧಿಕಾರದ ವರದಿಯನ್ನು ಅವಗಾನಿಸಬಹುದು. ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ನ್ಯಾಯಾಲಯದ ಆದೇಶವನ್ನು ಅನುಷ್ಠಾನವಾಗದಿರುವ ಬಗ್ಗೆ ಅರ್ಜಿದಾರರು ನ್ಯಾಯಾಲಯ ನಿಂದನಾ ಅರ್ಜಿಯನ್ನು ಸಲ್ಲಿಸಿದ್ದು ದಿನಾಂಕ 26/3/2014ರಂದು ವಿಚಾರಣೆಗೆ ಬಂದಿರುತ್ತದೆ. ಸದರಿ ದಿನಾಂಕದಂದು ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ 1 ವಾರದೊಳಗೆ ಸರ್ಕಾರವು ಅರ್ಕಾವತಿ ಬಡಾವಣೆಯ ಪರಿಷ್ಕೃತ ಯೋಜನೆಯನ್ನು ಅನುಷ್ಠಾನಗೊಳಿಸುವ ಬಗ್ಗೆ ನಿರ್ಣಯ ತೆಗೆದುಕೊಳ್ಳಲು ನಿರ್ದೇಶನ ನೀಡಿರುತ್ತಾರೆ. ಸರ್ಕಾರಿ ವಕೀಲರು ಸದರಿ ಪ್ರಕರಣಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಚುನಾವಣೆಯ ನಂತರ ಅನುಷ್ಠಾನಗೊಳಿಸಲು ಸಮಯವನ್ನು ಕೇಳಿದಾಗ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯವು ಒಪ್ಪದೆ ಈಗಾಗಲೇ ಸಾಕಷ್ಟು ಸಮಯ ನೀಡಿದ್ದು ಇನ್ನೂ ಹೆಚ್ಚಿನ ಕಾಲಾವಕಾಶವನ್ನು ನೀಡಲು ಸಾಧ್ಯವಿಲ್ಲವೆಂದು ತಿಳಿಸಿರುತ್ತದೆ. ದಿನಾಂಕ 27/3/2014ರಂದು ಬಿಡಿಎ ಆಯುಕ್ತರು ಬಿಡಿಎ ಇವರು ಸರ್ಕಾರಕ್ಕೆ ಸಲ್ಲಿಸಿದ ಅರ್ಕಾವತಿ ಬಡಾವಣೆ ಪರಿಷ್ಕೃತ ಯೋಜನೆಗೆ ಸಂಬಂಧಿಸಿದ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಕಡತದಲ್ಲಿರಿಸಲಾಗಿದ್ದು ಸ್ವಯಂ ವೇದ್ಯವಾಗಿರುತ್ತದೆ. ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯವು ಸೂಚಿಸಿರುವ ಎಲ್ಲ ಅಂಶಗಳು ನ್ಯಾಯಾಲಯದ ಆದೇಶಗಳು, ಪ್ರಾಧಿಕಾರದ ಠರಾವುಗಳು ಹಾಗೂ ಈಗಾಗಲೇ ಸರ್ಕಾರ ಕೈಗೊಂಡಿರುವ ಕ್ರಮಗಳು ಈ ಎಲ್ಲವೂ ಸೇರಿ ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ಒಳಗೊಂಡಿದ್ದು ಪ್ರಾಧಿಕಾರದ ಪರಿಷ್ಕೃತ ಯೋಜನೆ ಸರ್ಕಾರದ ಅನುಮೋದನೆಯನ್ನು ಕೋರಿರುತ್ತದೆ. ಅದರಂತೆ ಖಂಡಿಕೆ 3ರಲ್ಲಿ ಪ್ರಸ್ತಾಪಿಸಿರುವಂತೆ ಪರಿಷ್ಕೃತ ಯೋಜನೆಯನ್ನು ಅನುಷ್ಠಾನಗೊಳಿಸಲು
ಅಲ್ಲಿ ನೋಡ್ಕೊಳ್ಳಿ ಏನೇನು ಕೋರ್ಟ್ ಅವ್ರ ಮುಂದೆ ಆನರಬಲ್ ಚೀಫ್ ಮಿನಿಸ್ಟರ್ ಮುಂದೆ ಇತ್ತು ಅನ್ನೋದನ್ನಲ್ಲೇ ಹೇಳಿದಾರೆ ನೋಡಿ. 366 ನಲ್ಲಿ ಉಚ್ಚ ನ್ಯಾಯಾಲಯವು ಸೂಚಿಸುವ ಎಲ್ಲಾ ಅಂಶಗಳು, ನ್ಯಾಯಾಲಯದ ಆದೇಶಗಳು, ಪ್ರಾಧಿಕಾರದ ಠರಾವುಗಳು ಹಾಗೂ ಈಗಾಗಲೇ ಸರ್ಕಾರವು ಕೈಗೊಂಡಿರುವ ಕ್ರಮಗಳು ಈ ಎಲ್ಲವೂ ಸದರಿ ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ಒಳಗೊಂಡಿದ್ದು.
ಪ್ಲೀಸ್.
This is how it is. Then come to ಖಂಡಿಕೆ.
Lord, may kindly refer to Lord, the previous pages, Lord, at page 70, Lord.
70.
Page 70.
Yes.
Lord. Lord, sorry, Lord. Page 60, Lord. What has been referred to earlier, page 60.
60.
Yes. Lord, may kindly.
This is the list of things which they have
Yes.
referred.
This is at the end, Lord. Lord, may kindly see at the bottom 944 acres. The bottom.
Of this page. 944 acres.
944.
5 guntas.
Yes. Then, Lord, may kindly see, Lord, at page 76, the Honorable Chief Minister approves all the proposals.
Chief Secretary also has a additional Chief Secretary.
Additional Chief Secretary has put it for approval. ಅನುಮೋದಿಸಬಹುದಾಗಿದೆ.
Correct. That means after it passes through his scanning, na?
Scan. Yes.
Then it goes to Honorable Chief Minister.
Yes. Honorable Chief Minister approves it.
ಅಪರ ಮುಖ್ಯ ಕಾರ್ಯದರ್ಶಿ ನಗರಾಭಿವೃದ್ಧಿ ಇಲಾಖೆ.
Yes.
ಹೌದಾ?
ಹೌದು.
ಸರ್ಕಾರದ ಅಪರ ಮುಖ್ಯ ಕಾರ್ಯದರ್ಶಿ he has a 368. He has approved that.
360.
ಅಲ್ಲಿ ಶ್ರೀ ಸಿದ್ದರಾಮಯ್ಯ, the Honorable Chief Minister has put the signature.
Yes.
ಅಂದ್ರೆ ಗವರ್ಮೆಂಟ್ ಚೇಂಜ್ ಆದಾಗನೇ ಎಲ್ಲ ಡಿಸಿಷನ್ ಎಲ್ಲ ಬದಲಾಕೋತ ಹೋಗ್ತದೆ ಏನು ಬಿಜೆಪಿಯಲ್ಲಿ? ನಿಮ್ಮ ಇದರಲ್ಲಿ ನಿಮ್ಮ ಬಿಡಿಎದಲ್ಲಿ ಗೌರ್ಮೆಂಟ್ಸ್ ಬರೋದು ಪಾರ್ಟಿ ಬರ್ತದೆ, ಹೊಸ ಪಾರ್ಟಿ ಬರ್ತದೆ, ನಮ್ಗೆ ಹೊಸ ಬೇಕು. ಅವೆಲ್ಲ
But it
ಎಲೆಕ್ಷನ್
is-
ರೆವಲ್ಯೂಷನ್ ಇಂದ ಆಗಲ್ಲ ಇಲ್ಲ.
But as so far as BDA is concerned, that is the chief minister, that the person or a party doesn't make a difference to us.
ಅಲ್ವಾ?
Yes,
But-
it is a scheme which works
It's our chief.
and all the chief
That's how we
ministers
should
have.
look at.
Yes, then pursuant to this, on 14/6/2014, the final notification is issued. The revised modified scheme of the Arkavati layout is issued 14/6/2014.
This is 31/3/2000
31/3/2014.
ಅವ್ರ ಕೆಳಗಡೆ ನೋಡಿ.
1/4/2014 ಅಂತ ಹೇಳಿ ಅವರು ವಾಪಸ್ ಅಪರ ಕಾರ್ಯದರ್ಶಿಗಳಿಗೆ ವಾಪಸ್ ಬಂದಾಗ
ಬಂದಾಗ ಅವರು ಮತ್ತೆ ಅದ್ ನೋಡ್ತಾರೆ.
1/4/2014 ಅಂತ ಹೇಳಿ ಮಾಡ್ತಾರೆ. This is 31/3/2014.
Correct.
After this, after the chief minister's approval and after the state government's approval, 14/6/2014 revised modified scheme of Arkavati layout is published by the state government, deleting the 944 acres of a land from the purview of the acquisition proceedings. These 944, what was approved by the state government, never found a place in the second final notification. Not for convenience, I am referring it as second final notification. It is a remodified scheme of Arkavati layout notification. These 944 was never there. Lord, that was challenged before this honorable court. Lord, may kindly take note that given an order passed by this honorable court in WP 51929 of 2014, Lord, Justice Arvind Kumar's order.
Appointing committee.
Yes, appointing committee as to why it became necessary. Lordship may, please.
(465). Which paragraph?
Lord, I had not
other day
given.
read that?
Lordship may kindly take page 601, Lord, in the order passed by the learned secretary. Page 601. Lord, till then, Lord, cause title was there, Lord, I have not.
Really?
The cause title,
601.
please. Lord, may I read para 9, bro?
BDA pursuant to
Pursuant to the
direction.
direction issued, has conducted an
Directions issued by whom?
by sorry, I'll then, Lord, I'll take your lordships to para 3, Lord, at page 597 to give an full idea of this.
ಅಲ್ಲ ಈ ಡೈರೆಕ್ಷನ್ ಯಾರು ಕೊಟ್ಟಿದ್ರು?
Bondoram Swami's
Huh?
judgment. Honorable Supreme Court, Bondoram Swami's.
Not by government.
Not by the government.
Okay.
Please.
Yes, right.
The BDA pursuant to the direction issued has conducted an inquiry through the land acquisition officer by examining the applications and representations submitted by the various applicants and placed the said report before the board of the BDA. Subsequently, the BDA has approved the report and restricted the total area of 1,700 and it has to be 1,766.
176.07.
No, Lord, that has to be 1,766, Lord. It
Should
finds
be rectified.
yes. At the bottom, if your lordship would see the 1,766 is also there again, yes. But printing mistake. Acres of the land for the
This
acquisition,
should be 1,000.
766.07 acres.
0 is missing, huh?
No, Lord, 7616 is missing. 1766,
1766.
yes, 0.07. What is it?
0.07.
0.07. If the lordships could find that 1776 at the bottom of the page also.
Correct.
Lord, yes, married. But of acres of a land for acquisition by deleting 983.33 guntas by resolution number 79 of 2013 dated 12/2/2013. The deleted lands measuring 983.33 guntas included in 198 acres, 20 guntas denotified lands and 83 acres, 8 guntas of the lands in respect of which the acquisition proceedings had been already quashed by the different cases. on the report submitted by the BDA forwarded to the government, the state issued a modified scheme and thereafter a notification dated 18/6/2014 came to be issued, under which an extent of 1,766 acres, 7 guntas of the land was sought to be acquired. In this notification, which has been challenged in the writ petitions, apart from challenging the earlier notifications and also by some of the petitioners. My Lord, may I request, my Lord, page 604, my Lord. Summary of the contentions raised. I am reading it for the purpose as to say as to why
The committee came to be.
committee came to such a conclusion. May I read, my Lord? It is
Yes.
contended that the representation submitted by the landowners had been considered under section 17(5) of the BDA Act, and a notification under section 19 of the said Act came to be issued, which is bad in law, since the acquisition proceedings have already been upheld by this court and the Honorable Apex Court, and the BDA has been directed only to consider the representation, and such there was no need for a necessity to initiate issuance of a notification dated 18/6/2014. Once again, under section 19 of the BD Act, it is also contended that the Honorable Supreme Court in Bandu Ramaswamy's case has directed the BDA to consider the representation of the landowners as to the discrimination meted out to a similarly placed landowners, and instead of complying with the said directions, the BDA has recommended the government to denotify several lands, which is contrary to the dicta laid down by the Honorable Supreme Court. It is also contended that the second final notification dated 18/6/2014 is without authority of law, as the BDA Act does not provide for the same, and it has been issued under the Land Acquisition Act 1894, which has been repealed. It is also contended that the second final notification has been issued without application of man. Elaborating on this, it is contended that under the second final notification, 1666.5.
Consideration.
Please. No, Lord. Lordship may kindly take
Whether this
Okay.
judgment considers the proceedings of the Honorable Chief Minister also?
Yes, ma'am. Yes, that is what I referred to earlier to show to your lordship that the 983.33 acres is what was deleted by the approval of the state government, which earlier referred to
Oh, that within 1766 acres.
not 1766 acres was retained for acquisition by
After
deleting
deleting,
983 acres by virtue of an approval given by the state government. It will be clear, not here. Lordship may kindly take page 714.
31/3/2014 ಅಥವಾ 1/4/2014
Yes, ma'am.
Additional Secretary.
Yes, ma'am.
Honorable Chief Minister is 31/3/2014. ಅದ್ರ ಬಗ್ಗೆ ರೆಫರೆನ್ಸ್ ಎಲ್ಲಿದೆ ಇಲ್ಲಿ?
Lord, ಅದ್ರ ಬಗ್ಗೆ reference ಅಂತಂದ್ರೆ I'll read, not direct.
Is there, is it there or not ಅಂತ?
Not direct reference with regard to the approval, but the reference is with regard to those materials. May I read page?
ಅಲ್ಲೂ ಹೇಳಿಲ್ಲ ನೀವು ಕೋರ್ಟಿಗೆ.
ಇಲ್ಲ.
Honorable Chief Minister was misled
No, Lord, it was.
ಅಂತ ಅನ್ಕೊಂಡು ಎಲ್ಲಿ ಆ ಸ್ಟ್ಯಾಂಡ್ ತಗೊಂಡಿಲ್ಲ.
It was looked into by the learned single judge. Learned single judge looked into reports. Lordship may kindly, I'll read those. Lord.
Page?
Lordship may kindly take page 714. My apologies, sorry. Lordship may kindly take page 684.
684.
Yes. But the learned single judge has, on a day-to-day basis, my lord, had dictated certain orders while hearing some of the matters.
Yes.
Page 684, my lord, lordship may permit me to read 75.2. My lord, on 75.1, my lord, the contention of the BDA is recorded. 75.2 is the.
It has to be seen.
It has to be seen from the directions issued by the division bench, and also the clarification directions issued by the
Bandu
Apex
Ramaswamy.
Court in Bandu Ramaswamy's case, that the landowners whose lands have been locked are sought to be acquired, and residential sites are to be constructed in small pockets. Same could not serve the purpose for which the land is sought to be acquired. if the lands are not isolated pockets or it would form a major chunk, proposed acquisition would suffice for the BDA for the formation of a site, and it is not open for the petitioner to pretend that even in such circumstances also, the land proposed for acquisition are to be deleted. As already observed herein, under the guise of implementing, Lordship may permit me to read.
I have
As
read that.
already observed herein, under the guise of implementing the order passed by the Honorable Supreme Court in Bandu Ramaswamy's case, which has been in furtherance of orders passed by the division bench, whereunder several guidelines came to be issued but to the BDA to ensure that where the land sought to be acquired is a landlocked area, or in other words, island, and such a continuation of the acquisition proceedings would not be favorable in the interest of both the parties. Apex Court had also directed BDA to drop such pocket of the lands from being acquired, taking umbrage under this order. Officials of the BDA seems to have gone on spree of denotifying the lands by pick and choose methods. In other words, there being no transparency and obviously to favor such of those persons whom they thought is to be favored. The glaring example for such incidents can be noticed in respect of the land bearing so-and-so
89 of 1 of Nagavara.
Raghuara village has been produced by the Learned Panel Council appearing for the PDA boundaries as described in this so-and-so.
But they
Not-
found fault with the BDA,
Not, they find fault with PDA.
BDA, not government.
No, Lord, it is the recommendation which was sent by the BDA and the acceptance of the state government.
No.
So that is what is in that 983 acres is a discussion, Lord. I'll read further, Lord, it will be clear. Lords may kindly take next paragraph, next page, Lord.
See,
687, Lord.
officials of BDA seem to have gone on the spree of denotifying the lands by pick and choose methods.
Yes.
This is the finding.
Yes,
Any direction, any criticism of the government or governmental functionaries?
no.
There is nothing
Lordship,
like that.
There is not in this paragraph, but about 983, when I show it to your lordship may have to
Infer like that,
infer
proceedings of the,
not the proceedings. Lord, that is why it had become
Yeah.
essential. Lordship may kindly then take page 687. Page 687, last but 3 lines. Lord, may 687, last 3 lines. As such, this court has been. May I read?
as such, this court
Court
has been forced to observe herein
hereinafter
the strategy has been adopted by the BDA
by use
use
of a
of
pick and
but
choose
nimmele.
method to denotify the land, subsequent orders so and so passed with. It requires serious examination and officials who have indulged in such acts cannot go unpunished. However, truth has to be ascertained in that regard, and it is left to the authorities to consider these aspects for taking action against the erring officials. Lord, then I'll read the next paragraph. I'll skip 5 lines, bro. The 6th line, the BDA has undertaken the exercise. May I, Lord?
6th line.
Yes, Lord. After WA number 2.
BDA has undertaken the exercise as per
As
the
per the
directions issued by DB.
the division bench, and the process has denotified several lands on the premise that they would fall within the parameters indicated in the operative portion of the order passed by the division bench. And as such, the site landowners so and so entitled to relief sought for the land, and exercise undertaken by the BDA is erroneous and contrary to the fact. Assailing the same petitioners are before this honorable court seeking for a direction to BDA to reconsider the representation and also to quash the notification dated 18/6/2014.
That
Then-
Bandu Ramaswamy,
Yes,
the parameters which have been given by the DB and went to Apex Court.
Yes.
Apex Court added
The-
3 more
the
directions.
one direction with regard to isolated pockets of the
Pockets.
property. Yes,
And the second one is it may be in other villages also, same principle will be applicable.
Yes.
At least 2 more points are added. Now we are only asking you throughout the learned single judge's order, the focal point is the BDA only,
yes,
number 1. Functionaries under Bandu Ramaswamy are BDA only.
yes.
No role is assigned to the government. It appears that way
Right.
when I read that judgment, because since you are sitting on BDA matters also, Unless you show, yeah, we may be wrong also, we do not know. I may be wrong also. But I have seen the conclusion part
Please.
of Pondu Ramaswamy at the hands of the apex court.
Yes.
There it does not appear to have focused any central government, the state government at all. Does it?
But what happens is.
No,
under
I'm
the-
asking, we want
it-
ascertain
it
from
is-
you.
It's not specific direction to the state government. The direction was to the landowners to approach BDA to
BDA
make their,
shall take
to
a call.
ventilate their grievance with
Therefore-
regard to acquisition of their lands and say whether I fall within, whether any of these 6 particular guidelines. And if that is to be
That is
ascertained,
BDA will decide that.
then BDA will decide. However, my lord,
While
under the,
deciding, just we'll go step by step.
Yes.
The power to leave the lands that would fit into parameters of Pondu Ramaswamy.
Yes.
That is vested with the BDA because of the DB decision.
no, the power to delete any land from the purview of the acquisition proceedings is always in the domain of the state government and not in the BDA.
That is statutory scheme you are speaking of.
Section
But
7.
Pondu Ramaswamy,
Please.
kindly read, to
May I-
whom that power is given.
Lordship,
Conclusion part even.
please. Lordships,
What?
please, 377,
Ah.
para 160. In view of the foregoing, we affirm the directions of the division bench subject to the following further directions and clarifications. In regard to the acquisition of the lands in Kempapura, so and so, so and so. Lord, I'll skip this first 2 paragraphs, Lord, with referring to the first particular 2 villages. Then, Lord, the PDA shall give an option to
Ah.
each of the writ petitioners whose lands has been acquired for Arkavati layout to accept allotment of a 15% of the land acquired from him.
So
by-
role is
That
assigned
is
to
with
BDA.
compensation.
BDA.
That is with regard to
Subject- We are only saying who is the functionary under that Pondu Ramaswamy. Then go to next paragraph.
Yes. Ma'am. To accept the allotment, so in cases where the extent of the land acquired exceeds half an acre, to claim in addition to the compensation without prejudice to seek reference if he has not satisfied with the quantum, allotment of a plot measuring 30-40 for every half acre of the land acquired at the prevailing allotment price. This is
That's
also with
also
regard to compensation.
That's also BDA.
Compensation is also.
Go to DB judgment of, there is one more aspect, one more direction is there,
Yes.
which includes other villages.
Any allotment made by the BDA either in forming the
BDA
layout
again.
or by the way of a bulk allotment will be subject to
Subject to
That
above
is-
conditions.
yes.
Go to the conclusive, the parameters of DB.
DB. Yes,
Any role is assigned to the government.
yes. I'll. Three not two, Lord.
Sorry, my profound apologies, my lord. I was
Yes.
stuck in the first court.
No, it's
So
not-
sorry.
No,
So sorry.
your colleague was here and you had completed your argument.
Three not,
Only reply then thereafter.
three not two ಅಲ್ಲಿ ಇದೆ.
Three not?
Three not two ಅಲ್ಲಿ ಇದೆ.
Of that judgment.
Compilation ಅಲ್ಲಿ. ಆ 4 parameters, my lord, which the division bench had,
In your compilation,
ಅವ್ರು ಕೊಟ್ರಲ್ಲ, ನಮ್ಮ
ನಾನು
ನಿಮ್ಮ
ಕೊಟ್ಟಿದ್ದೆ,
compilation.
PDN ಅವ್ರು ಕೊಟ್ಟಿದ್ರೊಳಗೆ ಇದೆ.
302.
302.
Lord. Lord, ma'am.
ನನಗೆ ಒಂದೇ ಪ್ಯಾರಾಗ್ರಾಫ್ ಏನ್ ಬೇಕು ಅಂದ್ರೆ
Yes,
functionaries, because court did this in an extraordinary way.
yes.
They agree that way. It's a very
Yes,
unconventional order
Lord, the Honorable Supreme Court
and
says
has affirmed it.
to salvage the acquisition is a
That's-
word used.
So this is
But-
not simple principles which Rupert Krasner ತಗೊಂಡು ನಾವು interpret ಮಾಡಂಗಿಲ್ಲ. The larger canvas ಇದೆ ಇದಕ್ಕೆ.
Yes,
For that reason.
yes.
Any role is assigned to government
Lord,
in any of these, that it begins
Lord,
1A, B,
1A.
C, D, Romans
303 first paragraph ನೋಡಿ.
303.
303. In the event the BDA comes to the
Come
conclusion, the
conclusion.
lands of these persons similar pay, then to
then to
exclude the land
exclude
from
the
acquisition.
acquisition. Lord, may I make?
Two things we have just.
Yes,
On your own, what all you can do
yes,
and how you can grant relief to the citizens whose lands you wanted to take, you had taken or you have deleted. That power is vested in you.
Lord.
That appears to be like that only, unless you show the contrary.
No, Lord,
Number
Under
one.
under the scheme of the.
ಅಲ್ಲ ನಮ್ದು ಇನ್ನೂ ನಮ್ಮ
Sorry,
version,
sorry.
we have understood.
Sorry.
We are telling this. the functionaries under this judgment
Please.
are none other than BDA officials. Correct?
Yes.
Correct or no?
Correct.
correct.
The act of the acquisition, Lord, is a land acquisition officer is an officer of the state.
ನಾವು ಇದ್ರ ಬಗ್ಗೆ
Yes,
ಮಾತಾಡ್ತಾ ಇದ್ವಿ, ಈ
yes.
ಜಡ್ಜ್ಮೆಂಟ್.
ಅದೇ.
ಈ ಜಡ್ಜ್ಮೆಂಟ್ ನಲ್ಲಿ ಫಂಕ್ಷನರೀಸ್ ಯಾರು ಅಂದ್ರೆ BDA ಅವರು ಮಾತ್ರ. ಇದನ್ನ ನೀವು ಕಾಂಟ್ರಾಡಿಕ್ಟ್ ಮಾಡ್ತೀರಾ, ಕ್ವಾಲಿಫೈ ಮಾಡ್ತೀರಾ. ಈಗ ಮುಂದೆ ತೊಗೊಂಡು ಹೋಗ್ಬೇಕು ನಾನು ಅದ್ರ ಮೇಲೆ, ಅದಕ್ಕೆ
Yes. But
we are laying. Kindly do not assume that we are cross-examining.
No,
We want to elicit information from you because you represent a statutory body.
under this judgment, Lord, the liberty was granted for the BDA
Only
to do
BDA.
to the act.
Is it?
To read by
The
reading.
government does not figure anywhere here.
304 ಅಲ್ಲಿ ತಾವು ಬಂದ್ರೆ ಪೇಜ್ 304 ಬನ್ನಿ.
304.
ಅದರಲ್ಲಿ ಫಸ್ಟ್ ಪ್ಯಾರಾ 2 ನಲ್ಲಿ ಲಾಸ್ಟ್ 5 ಲೈನ್ಸ್ ಬನ್ನಿ. ಆನ್ ಸಚ್ ರೆಪ್ರೆಸೆಂಟೇಷನ್ BDA Tata
Consider the request and pass appropriate orders.
in the event their contention is upheld, the state land shall stand excluded straight away.
Therefore, no role is assigned as such to the government at all. This is one aspect of the matter.
Yes.
This order does not exclude the statutory permissible intervention of the government in your BDA process. Do you agree with this?
Yes.
That is the purport of section 65 which you have read.
Yes.
Is it?
Yes.
So if the government of the day takes a decision, even those decisions should be upset ಅನ್ನೋ ಬಗ್ಗೆ ಎದ್ರಲ್ಲಿ ಯಾವ ಆಧಾರದ ಮೇಲೆ ನಾವು ಕನ್ಸ್ಟ್ರೂ ಮಾಡ್ಬೇಕು ಈ ಜಡ್ಜ್ಮೆಂಟ್?
No, I am not on that point for a moment, at any
No,
point. of-
we are on the point.
No.
Can you dishonor
No, Lord.
order of the honorable chief minister?
No.
ಇದು ಒಂದ್ ಕೇಸ್ ಅಂತ ಇಟ್ಕೋಬೇಡಿ.
ಇಲ್ಲ, ಎಲ್ಲ ಕೇಸ್
ನಾಳೆ ಬರುವಂತ
ಮಾಡಕ್ಕಾಗಲ್ಲ.
ಕೇಸ್ಗಳದ್ದು ವಿಚಾರ ಮಾಡಿ. ಇದ್ರಲ್ಲಿ ಏನೋ ಒಂದು ಇಲ್ಲ ಯು ಕ್ಯಾನ್ ಡಿಸಾಲ್ವ್ ಅಂತ ಹೇಳ್ಬಿಟ್ರೆ ನಾಳೆ ಉಳಿದಂತದ್ದಕ್ಕೂ ಬರ್ತದೆ. It amounts to challenging the authority of the honorable chief minister,
Lord, I can't.
which we cannot do.
Yes. Lord, may kindly take note, section 65B of the BDA Act.
That's
Lord, may
Yeah.
kindly take 65B makes it mandatory. Sorry.
You were not required to approach the government
Government
under
at all.
this judgment.
full authority.
Full authority was vested with you. There was no necessity for the upper Karyadarshi or whoever he may be to go to him
No.
and to the chief minister.
65B.
And even then you invoke
ಅದು ಅದಕ್ಕೆ
65.
65B.
independent of this ಅಂತಾರ.
65B mandates me
Mandates
that.
that you have to do.
that I have to do.
And then you have to, if you go to chief minister and say 65B says that you have to abide by what the government directs,
Yes.
then you have no discretion to disobey.
No, Lord, I have not disobeyed. Not my respectful submission is to 2014 notification deleting that 983 acres of the land, including the land of the petitioner, was accepted by the BDA. It is not that, Lord, after the government takes a decision, I send a remodified scheme to the state government for approval. The state government approves it by deleting this 983. I was never on a case that the state government, you ought not to have deleted 983. That was never my stand. I can never take that stand. That is not permissible under the BDA Act also.
ಇನ್ನೊಂದು ಕ್ವಶನ್ ಕೇಳ್ತೀನಿ.
Yes,
ಅಲ್ಲಿ ಗವರ್ಮೆಂಟ್ ಒಂದು ಆರ್ಡರ್ ಇದೆ ಅಲ್ಲ,
please.
ಸೈನ್ ಬೈ ಆನರಬಲ್ ಚೀಫ್ ಮಿನಿಸ್ಟರ್. ಆ ಆರ್ಡರ್ಗೆ ಏನು ಲೀಗಲ್ ಸಿಗ್ನಿಫಿಕೆನ್ಸೇ ಇಲ್ಲ ಅಂತೀರಾ, ಕಾನ್ಸಿಕ್ವೆನ್ಸ್ ಇಲ್ಲ ಅಂತೀರಾ?
No, it's binding on me. Yes. But that is found fault with by the learned single judge.
ಅದ್ರ ಬಗ್ಗೆ ಎಲ್ಲಿದೆ?
ಇದೆ, ಅದಕ್ಕೆ ಏನು
ಚೀಫ್ ಮಿನಿಸ್ಟರ್ಸ್ ಇದನ್ನ
ಎಲ್ಲ ಚೀಫ್ ಮಿನಿಸ್ಟರ್ ಬಗ್ಗೆ ಅಲ್ಲ, ಎಂಟೈರ್ ಎಕ್ಸರ್ಸೈಸ್ ಬಗ್ಗೆನೇ ಇದೆ. Lordship, that's why why I'm reading is, Lord, the chief ministers, Lord, under 19, Lord, under state government, not, Lord, sorry, pardon me for saying chief
ಯಾಕೆ?
minister.
ಹೇಳಿ.
Lord, it's a state government.
ಉಪಯೋಗವಾಗಿ ಹೇಳ್ಬೇಕು. Even you are not the mouthpiece of BDA. You are a council.
Yes. Lordship, may kindly permit me as to what the learned single judge, Justice Arvind Kumar has observed with regard to the entire conduct of deletion of all these 983 lands.
Conduct
And-
of
Conduct of the BDA, state government and the board. They have,
government also.
ಮೂರನ್ನು ಬರ್ದಿದ್ದಾರೆ. ಅದಕ್ಕೆ ನಾನು ಓದ್ತೀನಿ ಅಂತ ಹೇಳಿ.
ಯಾವ್ದದು? ಅದು ಓದಿ.
Lordship may
ನಿಮ್ಗೆ ಏನೇನ್
kindly
ಬೇಕು
take,
ಅಷ್ಟು.
Lordship may kindly take page 714, para 82. Lordship, I'll
Of
take them
memo,
of the memo of the learned single judge judgment, my lord, of Justice Arvind Kumar.
judgment. Paragraph?
82, my lord, 7 page 714, my lord.
Yes.
Please.
As observed here in above.
As observed here in above, my lordship, I'll trouble your lordship with two, three
ಏನ್
pages.
trouble ಇಲ್ಲ. We are
2-3
we are
pages.
enjoying your argument.
2-3 pages, I'll trouble your lordship.
ಹೇಳಿ.
Please. As observed herein above, the BDA was required to undertake the exercise examining the claims of respective parties as directed thereunder. BDA was also required to comply with the further directions and the clarifications issued by the Honorable Apex Court. In other words, it had to ascertain whether the claims of the applicants would fall within the four corners of the parameters fixed by the division bench as well as by the Honorable Apex Court. In this direction, BDA has undertaken a mammoth exercise of conducting a spot inspection, ascertaining the age of the buildings existing, if any, namely so as to whether such a building came up before the issuance of the preliminary notification or after the final issuance of the thereof. And the Special Land Acquisition Officer have submitted their reports. In fact, some of the reports which have been filed have also been challenged or attacked in these writ petitions on the ground that they have been contrary to the factual matrix. We have already enumerated as to how such reports are either being erroneous or either contrary to facts. This court, in exercise of its jurisdiction under Article 226 and supervisory jurisdiction under Article 227 of the Constitution of India, would not be in a position to fathom the truth or otherwise of the exercise undertaken by the BDA. It would also be necessary to note at this juncture that after issuance of the preliminary notification, sites have been purchased from erstwhile owners. There are instances where prior to issuance of the preliminary notification, revenue sites have been purchased by few of the petitioners. They are said to have put up the construction. There are instances where constructions have come up in accordance with the building plan or license, so and so, so and so. Lord, then may I skip not these two paragraphs?
ಅದರಿಂದ ಏನ್ ಹೇಳಿ ಓದಿದ್ವಿ ನಾವು. ಅದಾದ್ಮೇಲೆ ಮತ್ತೆ 3 ಪೇಜ್ 3 paragraph. What you wanted to derive from, what milk you want to draw from
The
this?
learned single judge says the reports of the BDA are being erroneous or contrary to the facts. One aspect is an observed. Further, I'll read. Lordship may kindly take, my lord, page 719, my lord.
719.
Yes.
Yes.
Para
Refer to-
83.2. However, ma'am, however, the fact remains that the pursuant to the final notification dated so and so, where under an extent of 2,750 acres of the land was sought to be acquired for the purpose of formation of a layout. Land in question has been acquired and sites have also been
ಆ
started.
ಬಂಡೂರು ರಾಮಸ್ವಾಮಿ ಅದೇನ್ ಹೇಳ್ತಾ ಇದಾರೆ ಅಂದ್ರೆ, ಬಂಡೂರು ರಾಮಸ್ವಾಮಿ ಪ್ಯಾರಾಮೀಟರ್ಸ್ ನ ಅಬ್ಯೂಸ್ ಮಾಡಿ 900 ಆಡ್ ಏಕರ್ಸ್ ಅನ್ನ ಡಿಲೀಟ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಆ ಪ್ಯಾರಾದಲ್ಲಿ.
ಇದೇ 983 acres ಯಾವುದು ಅಂದ್ರೆ which has been approved by the state government. Your lordships had seen that 983 acres. That 983 acres is what the learned single judge is referring to. Lordship may kindly further permit me next, my lord. Lordship may kindly take the next fourth line in the
paragraph.
Please. In the photograph which has been produced at annexure so and so perused by this court, which would clearly indicate that except a building of the petitioner, surrounding land which can be seen seems to be more than several acres which are lying fallow and vacant, and yet same has been denotified. Circumstances in which lands have been denotified cannot be beyond the parameters fixed by the division bench as well as the Honorable Apex Court in Bandu Ramaswamy case.
ಅಲ್ಲಿ ಬಿಡಿ ಇನ್ಸ್ಪೆಕ್ಟರ್ಸ್ ಎಲ್ಲ ಹೋಗ್ಕೊಂಡು ಇದನ್ನೆಲ್ಲ ಮಾಡಿದ್ದಾರೆ ಅಂತ
Next, crucial. However, on perusal of the records made available by the BDA and various reports, it would disclose that in several cases where the Special Land Acquisition Officer has undertaken the exercise visiting the spot along with the Revenue Inspector, has recommended for denotifying the lands, and the BDA on the ground that there is inconsistency between the said report as well as the report of the Assistant Commissioner has not been accepted. The reports of the Special Land Acquisition Officer and thereby has not deleted or denotified certain lands. However, intriguing circumstances, this case would unfold is that fact that large tracts of the lands, though vacant, not developed and not falling within the parameters fixed by the division bench of the Honorable Apex Court has also been deleted or denotified. In this background, the exercise so undertaken by the VDA requires to be scrutinized at a micro level. Then, Lord may kindly,
Whether 65 and 65B
please,
are applicable for functioning under the Bondu Ramaswamy?
Lord, it is 65B, Lord, insofar as the acquisition is concerned, Lord, it comes to a scheme that I'll have to follow certain things of the state government. It is not a day-to-day affair, Lord. Scheme of a development is it falls within
No,
65.
we are asking you.
Yes.
Under Bondaswamy, ನೀವು ಏನೇನ್ ಡಿಸಿಷನ್ ಮಾಡಿದಿರಲ್ಲ ಈಗ
ಹೌದು sir.
ಅದರಲ್ಲಿ ಮಾಡುವಾಗ ನೀವು reported it to the government and government directed and then you followed the direction. Is it your stand or you will do it on your own?
Lord, I did it on my own by virtue of order passed by the Honorable
Court.
Supreme
Therefore,
Court.
65B are out of your sight. When
65
functioning.
65B is there, I followed.
65B arises only if there is 65 direction.
No, Lord, 65B, no, every resolution I'll have to send it to the
Correct, to the government.
government.
Correct.
Then the government takes a decision, I'll have to follow it. That is how it is 65B. May I read?
Even for deletion of other things ಮಾಡ್ತಿರಲ್ಲ.
Lord, I can't delete only.
No. Under Bondu Ramaswamy.
ಸ್ವಾಮಿ ಅಲ್ಲೂ ನನಗೆ ಡಿಲೀಷನ್ ಪವರ್ ಕೊಡ್ಲಿಲ್ಲ.
ಏನಿಲ್ಲ.
ನಾನ್ ಡಿಲೀಟ್ ಮಾಡಕ್ ಬರಲ್ಲ. ಯಾಕಂದ್ರೆ ನಾನು ಐ ಕ್ಯಾನ್ ಓನ್ಲಿ ಸೆಂಡ್ ದ ಮಾಡಿಫೈಡ್ ಸ್ಕೀಮ್ ಟು ದಿ ಗವರ್ಮೆಂಟ್.
Kindly read Bondu Ramaswamy last 30. Mr.
30.
Valla has read that, na?
Yes, Lord.
304. Automatically it stands excluded.
That's why.
Automatically stands excluded only insofar as petitioner's property. This petitioner, because there was a dispute between the present petitioner and Tata Housing. If Tata Housing succeeds, it will go to Tata Housing. If Tata Housing doesn't succeed in establishing
Acquisition
provisionally
stands
established,
upheld because they have given consent to
Yes.
that. And
this
then
petitioner will lose because he had already agreed. That is how the words used there.
ಈಗ Bondu Ramaswamy ಕೆಳಗಡೆ ಇಷ್ಟೊಂದು 1000 ಕೇಸ್ ಡಿಸೈಡ್ ಮಾಡಿರಲ್ಲ ಈಗ
ಹೌದು ಸರ್.
ಅಲ್ಲೆಲ್ಲ ನೀವು ಗವರ್ಮೆಂಟಿಗೆ ಕಳಿಸಿ ಅವರಿಂದ ಅಪ್ರೂವಲ್ ತಗೊಂಡೇ ಮಾಡ್ಕೊಂಡಿದ್ದೀಯಾ?
ಹೌದು ಸರ್. ನಾವಂತೂ ಯಾವುದನ್ನು ಒಂದನ್ನು ನಮ್ಮಲ್ಲಿ notification of a deletion is not there. I can't even issue a notification of deletion at all. It is a final notification which has to come under section 19 is by the state only, or under 48(1) is also by the state only. I can't do it. But that is then Lordship would kindly turn to page 728, what the learned single judge observes.
728.
In fact, the last 4 lines,
In fact, it would not have been
could not
difficult for
have been
PDA to
difficult
place
for
on
a
record.
PDA to place on record with reference to each of the writ petitions as to whether the claim would fall in any of the category or condition stipulated in judgment of division bench so and so stated supra. If so, the manner in which such consideration has taken place or had been considered by the BDA or net result of such consideration, as noticed here in above, the BDA seems to eager and anxious to withhold such details or information from being made available to the court. Then Lordship may kindly see, then I'll skip. Lordship may kindly take page 88, para 88, page 734. After reading this, I think this would be
Para
88.
even according
Even
to
according to
PDA.
BDA, subsequent to FFN, that is 2014 notification. Dated, the FF, first final
23 to
notification
2004.
4 and prior to issuance of the modified notification
That
dated
is 18/6/2014, about 988 acres of the land has been denotified, for which acceptable and justifiable reasons are lacking. To put it differently, facts discussed here in above are contrary to the stand of the PDA. In the light of the aforesaid facts, this court is of the considered view that these aspects will have to be dealt by examining the claims afresh and ensuring there is a clear and absolute transparency in the said process. It would be apt and appropriate to constitute a committee. The committee is accordingly constituted, comprising of following so and so, so and so. Then,
Lordship may kindly take the order operative portion. The acquisition challenge to my preliminary first final notification, second final notification, all are rejected. Then Lordship may kindly take Lot 741, page 741, Roman 14, Lord. This is the direction given to the committee, Lord.
All deletion.
All the deletions or denotification recommended by the PDA or made by the PDA or by the government is subject to the certification or approval by the committee to the effect that such deletion of the land is in accordance with the law laid down by the division bench and direction clarification issued by the Honorable Supreme Court in Bandu Ramaswamy's case.
So according to you, this decision includes that the CM's decision
Yes,
also.
yes. Because that 983 acres is what is specifically referred to by the learned singer. That is why I had to read all those.
980, that is after 1066, ಅದೇನು ಆಮೇಲೆ ಉಳಿದಂಥದ್ದು.
How 983 was deleted under the guise of exercising the powers conferred by the Honorable Supreme Court of
Bandu
India.
Ramaswamy.
Bandu Ramaswamy. Yes. But then, Lord, Lordship may kindly see, Lord, the 744. What is the dictum of this Honorable Court to the committee? The committee 20, Lord, Roman 20.
744.
744, Roman 20.
The committee.
The committee constituted herein above shall implement the order passed in writ appeal 2624 of 2005. This is the Honorable Division Bench order and connected matters on 21/11/2005 in the matter of the Commissioner BDA and others versus State of Karnataka and others, Secretary and others. And the order passed by the Honorable Supreme Court of India in civil appeal number so and so matters on 5/5/2010 in the matter of Bandu Ramaswamy and others. And in addition to the same, the said committee shall also examine all such representations. Lord, Lordship may permit me to skip that, Lord. The beam, Lord. Lord, the committee shall also consider the representation.
The landowners.
Yes, ma'am. Then Lordship may kindly take D, Lord.
The committee shall
The
examine. as to
committee
whether
shall examine as to whether the claim of the landowners for deleting their land from being acquired
Within the
within
parameters
the
of-
parameters, so and so. Lord, and then Lord, E,
As to whether
the
deletion
committee
of
shall
lands from
examine
acquisition.
as to whether the
The
deletion
deletions
of
which have
the
already
land
been
from the
done Are
acquisition.
within a parameters of Bandu
Yes,
Ramaswamy.
D already made by the deletions which have been made are also within the parameters of Bandu Ramaswamy or not. The committee shall examine as to whether the deletion of the land from the acquisition made by the BDA is within the parameters fixed by the division bench and Bandu Ramaswamy case by examining every such deletion made on case-to-case basis and particularly with reference to the deletion on the ground that the adjacent lands are having been deleted. Lordship may kindly then H also may be seen. No? H, no? The committee shall examine as to whether the deletion of 983
0.12
acres of the land by the government subsequent to the notification dated so and so and before issuance of a notification dated 18/6/2014 was in accordance with the dicta laid down by the Honorable Division Bench and in compliance with the directions clarifications issued by the Honorable Apex Court in Bandu Ramaswamy's case and submit a report to the PDA who shall take steps based on the said report. Yes. Then, Lord, Lordship may kindly take 752, Lord, L, Lord.
Committee would be at
The committee would be at liberty to examine as to whether the PDA has undertaken any exercise to delete the land suo motu, and if it is found so, if it is so found, the exercise so undertaken by the PDA would stand fast if it is not in conformity with the order passed by the division bench as confirmed and clarified by the Apex Court. to which effect the committee shall submit a report to the BDA, and on such report being submitted, the deleted lands would stand
restored
restored
to
to the
BDA
BDA
for
for
formation
purpose
of
of formation of a site in Arkavati layout to be allotted by the applicants in waiting.
Yes.
Not under these circumstances.
This matter, this order is not put in challenge.
No, this was not, some of them were challenged, not they have been dismissed by the division.
In writ appeal, this is
Yes,
affirmed by
dismissed,
the.
yes. But my respectful submission is, insofar as the lands which were deleted, 983 acres of the lands which were deleted by virtue of an action by the PDA, state government, all these were subject to the certification of the honorable committee constituted by this honorable court. Not the honorable committee looked into whether the lands of the petitioners would fall within the parameters of the
Vandu Ramaswamy.
Vandu
And then
Ramaswamy
they have
case.
come to
And
this.
there is a finding given by the honorable committee stating that it doesn't fall within the, but maybe the committee has gone a little ahead or may not have gone a little ahead. But the fact remains that the order of the Honorable Supreme Court and the division bench of this Honorable Court has been followed by the committee is my respectful submission. Not, in fact, one more aspect. Not before the committee, Lord, I don't appear as a litigant, as a BDA. I appear as a facilitator by virtue of the order passed by this itself, saying that.
There is an observation only to that.
Yes, yes,
BDA.
yes, and say that committee is required to take the technical assistance
From BDA.
from BDM, Lord, and any other officers if required. Not as in that, Lord, I appear before. I don't appear as a contesting party. Please.
Thank you.
Great.
We are coming back within 3-4 minutes.
Please.
We are coming back.
ಇದು ಟಾಪೇ ಕಾಣಿಸಲ್ಲ ಇಲ್ಲ ಇದೆ ನಾನು ಮಾಡಿದ್ದೀನಿ ಹೆಂಗೆ ತಾನೆ
anything then. But appeals are all different. No, that is different. Review is 980 pending. No, not spending on that. Because your entire arguments is on 980. All of it is correct. Delete ಆಗಿದೆ. ಕೆಲವು delete certificate ಅದನ್ನು ಅದೇ
ಹೇಳಿ ಬೇಗ ಹೇಳಿ.
By virtue of the honorable division bench order, wherein if the Tata Housing were to succeed, SATs automatically cancel the capital. If the Tata Housing were to succeed in establishing promissory estoppel, the acquisition would lapse. Acquisition would stand cancelled. If the Tata Housing were to fail in establishing, the
Acquisition will be upheld because
acquisition
they have
will be-
consented to that.
that is, it will it will be included. Not pursuant to the order passed by the Honorable Division Bench, Tata Housing came before BDA. And Lord, in 15/6/2006, Lord, we rejected their claim for deletion.
Tata's
Yes, their claim was rejected on 15/6/2006. That rejection was not set aside by any court.
15/6
2006.
ಅದು ಅದೆಲ್ಲಿದೆ ಅದು?
I have produced it along with my memo.
That was pursuant to order of Justice KR Saab's order ಅದು. ಅಲ್ಲ, it cannot be.
Justice, Honorable Justice Sondhi and Justice Kumar's judgment, Lord, Division Bench.
ಅಲ್ಲ. Pursuant to that judgment, they came before the committee.
They came,
BDA.
not committee, Lord,
BDA.
BDM, Lord. As per the directions of the Honorable Division Bench, they said they were supposed to make a claim for promissory estoppel and BDA were to consider it. If BDA considers in favor of Tata Housing, no further acquisition. If BDA rejects it, then it falls. within-
Automatically, the acquisition is upheld because they have consented to,
Yes,
they
and-
agreed to acquisition.
Acquisition, and Lord, that portion in the Division Bench, Honorable Division Bench very categorically says it gets included in the acquisition and BDA to proceed further. Then, in 2005, after the Division Bench order, Lord, they make a representation to us. I have produced it, Lord. And in page 38 of my memo, we have rejected it, saying that it is not, you are not entitled.
ನಿಮ್ಮ objection statement ನಲ್ಲಿ ತೊಗೊಂಡ್ರ ಅದನ್ನ contention? Have you
That-
taken up that contention in your written?
But that was
objection?
not according my respectful submission, Lord. When they go before the committee, but they never dispute a fact that.
ಅಲ್ಲ, ಆ
Lord, this-
fact ಹೇಳಿರಾ ಅಂತ?
Lord, in my memo and all production of documents, I have said so. ಎಲ್ಲ ಹೇಳಿ. And it is in their writ petition itself, they themselves have produced that document before this honorable court, where, Lord, it is an admitted fact that the Tata accepts that I have rejected it. Lord, may kindly take the writ petition itself. Writ petition ಎಲ್ಲೋ ಇದೆ ನೋಡಿ ಬೇರೆ.
In the writ petition,
Writ petition, page 59, Lord, annexure C. Annexure C, page 16, Lord, would be relevant. The rejection is referred to by this. Page 16.
6 May 2008.
Please, this was one more representation which they submitted. Lord, may I kindly take page 16, Lord. After this serial number 10, Lord. It is clear from the above that the
plea of promissory estoppel
promissory estoppel has been conclusively held against the BDA. Therefore, we had sought for deletion of the aforesaid lands from the acquisition. The BDA in its letter dated 15/6/2006 has proceeded to reject our request without providing any cogent reasons. In the said letter, it has been stated that the said plot does not come under the High Court guidelines and necessary required for the formation of Arkavati. This is what is the letter which was addressed by Tata Housing to me. My rejection is not challenged, is not set aside by the Tata
do
Housing.
you have copy of rejection order with you?
Yes, Lord, I have.
Have you produced? No.
Yes, Lord, I have. Lord, at page 38 of the memo filed on 31st January 2025. May I read, Lord?
Page number?
Page number 38, my lord. Timbara.
Who has taken this decision?
My lord,
Who has taken this decision?
Lordship may kindly see. On second paragraph, email ಕಾರಣಗಳಿಂದ.
Who has
ಮಾನ್ಯ-
taken this decision?
Lord, this decision was taken by the board and communicated by the land acquisition officer.
Board has taken that.
Yes, Lord.
Tell
Lord, it is referred to email ಕಾರಣಗಳಿಂದ third paragraph. Lord. ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಆದೇಶದನ್ವಯ ಹೆಣ್ಣೂರು ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ ಗುಂಟೆ ಜಮೀನು ಭೂಸ್ವಾಧೀನ
ನೋಡಲ್ಲ, ಉಪ ಆಯುಕ್ತರಿಂದ ಅನುಮೋದಿಸಲ್ಪಟ್ಟಿದೆ.
ಕಾರಣ ದಿನಾಂಕ 31/5/2006 ನಡೆದ ಪ್ರಾಧಿಕಾರದ ಸಭೆಯಲ್ಲಿ ವಿವರವಾಗಿ ಚರ್ಚಿಸಿ ನಿಮ್ಮ ಮನವಿಯನ್ನು ತಿರಸ್ಕರಿಸುತ್ತೆಂದು ಈ ಮೂಲಕ ತಿಳಿಸಲಾಗಿದೆ.
This is only intimation about the
About the board decision, endorsement. I have produced those documents also. Lordship may kindly take page 45, where the petitioner accedes to the acquisition. This was the time when.
No, that's recorded by the
Honorable Division.
judgmental, Justice
And-
Kumar's judgment.
Yes, Lordship may kindly take, I wanted to point out the status of the land, which as on the preliminary notification, as on the final notification, because the Honorable Learned Single Judge restricts consideration from final notification, 2004 notification. What was to be considered was the status of the land as on 2004, not on 2014.
Not second notification.
No
at all.
second notification, as of 2004, even Banduram Swami's case, even division.
Speaks of that one.
Yes, and the Honorable Learned Single Judge, Justice Arvind Kumar also restricts it to 2004. Lord, Lordship may kindly refer to the page 58 onwards, the status. ಎಷ್ಟು ನಾವು ಸೈಟ್ ಮಾಡಿದ್ವಿ ಅದು ಎಲ್ಲ ಒಂದು 53 ಇಂದ I had referred, no? That time 54 I had referred. Then Lordship may kindly refer to page 58. This was prepared as on 25/11/2005.
21 ಹೆಣ್ಣೂರು ಗ್ರಾಮದ ಗುಂಟೆ ಜಮೀನು ಸ್ಥಳ ತನಿಖೆ ನಡೆಸಲಾಯಿತು. ಮೇಲ್ಕಂಡ ಜಮೀನು ಪೂರ್ಣ ಖಾಲಿ ಇದ್ದು ಈಗಾಗಲೇ ಪ್ರಾಧಿಕಾರವು ಬಡಾವಣೆ ನಿರ್ಮಾಣ ಮಾಡಿರುತ್ತದೆ. ಈ ಜಮೀನಿನ ಅಕ್ಕಪಕ್ಕದ ಜಮೀನುಗಳಾದ 13/1, 16/1, 16/2, 16/3, 27/94 ಭೂ ಸ್ವಾಧೀನಕ್ಕೆ ಒಳಪಟ್ಟಿರುತ್ತವೆ.
Yes, that means your land will not become an isolated pocket of a land to get it deleted. No sites were formed. The allottees had come challenge this deletion. They were there before the committee. The allottees are there before the committee. They were there before the committee when this matter was taken up. This order is when the committee passes an order.
It is allotted to the others
Allotted
now.
to the general public.
ಸೇಲ್ ಡೀಡ್ ಮಾಡಿಕೊಟ್ಟಾಗಿದೆಯಾ?
How they were before the committee, Lord. If your lordships could see the impugned
No,
order.
where have you stated it has been allotted to the committee and the sale deeds have been executed? ನಿನ್ನೇನು ಇನ್ನೊಬ್ಬ another body council ನೀವೇನಾ ಯಾರು ಬೇರೆ? But we spent more than an hour and last sentence was they are not parties to the petition.
No, what I am trying to, what I showed it to your lordship, sir.
No, I was asking whether any sale deeds have been executed in their favor.
Yes,
Huh?
yes.
Where have you stated?
Not here, I have only.
You said that in your objection statement.
Yes. But I have taken, ಇಲ್ಲ, I have
ಯಾವ್ದು
taken,
ಇರ್ಲಿಲ್ಲ.
I have taken,
ಯಾವ್ದು ಇರ್ಲಿಲ್ಲ, ಅಲ್ಲ ಹೊಸ ಆರ್ಗ್ಯುಮೆಂಟ್ ಗಳು ಮಾಡ್ತಾ ಇದ್ದಾರೆ, ಇಲ್ಲಿ ಪರವಾಗಿಲ್ಲ.
ಇಲ್ಲ,
But I point out
Lord, I'll just show, Lord, I have taken non-jointer of necessary parties. I have taken it as a ground, Lord,
ಎಲ್ಲಿದೆ?
in the, my,
ಅಲ್ಲ ಹಂಗ್ ನಾನ್ ಜೆಂಡರ್ ಇಸ್ ಬ್ಯಾಡ್, ಸೂಟ್ ಈಸ್ ಬ್ಯಾಡ್ ಫಾರ್ ನಾನ್ ಜೆಂಡರ್ ಆಫ್ ಪಾರ್ಟಿ, ಹಂಗ ಹೇಳಿಕ್ ಬರಲ್ಲ.
because a lot
ಯಾರು ನೆಸರಿ ಪಾರ್ಟೀಸ್
is,
ಅವ್ರನ್ನ ಮಾಡಿಲ್ಲ ಅಂತ ಅವ್ರ ನೇಮ್ ಮಾಡ್ಬೇಕು
is, Lord,
ಹಿಂಗ್ ಹೇಳ್ತದೆ ಅಪೆಕ್ಸ್ ಕೋರ್ಟ್. ಬರೀ ಆ ಸೆಂಟೆನ್ಸ್ ತಗೊಂಬಿಟ್ರೆ ಆ ಮೊಗನ್ ಪ್ರೀಡಿಂಗ್ ನಲ್ಲಿ ಇಟ್ಕೊಂಡಿದ್ದು ಒಂದ್ ಸೆಂಟೆನ್ಸ್ ಹಿಂಗ್ ಹೇಳ್ಬಿಟ್ರೆ ಮುಗಿಯಲ್ಲ ಅದು. ಯು ಹ್ಯಾವ್ ಟು ಶೋ ಹೂ ಇಸ್ ದಟ್ ಪರ್ಸನ್ ಹೂ ಇಸ್ ಲೆಫ್ಟ್ ಔಟ್.
I'll just. Lord, Lord, may kindly permit me, Lord,
ಹಾ,
that,
ಪ್ಯಾರಾಗ್ರಾಫ್
para 12, Lord, of my statement of objection. It is submitted, wherein
ಹಾ.
it is
In the writ
submitted that
petition
the
have put
petitioners
up
in the writ petition have put up a note in page 8 of the writ petition, Lord, stating that the allottees of the BDA are not a necessary party. However, there is a specific recommendation from the committee stating that the BDA shall take all steps to
Absolute
execute
absolute
absolute sale
sale
deeds in
deeds.
favor of such allottees of the sites in the land in
No, that,
question. Under
com-
such circumstances.
that itself is put in challenge now.
No, Lord, they were,
Committee's
yes,
recommendation itself is
may I request your lordships to kindly see the impugned order. They were the parties. They were the petitioners before the committee. Lordship may kindly take the page number 80.
Hmm?
Page number 80. 80 of the writ petitions.
ಪಿ ವಿ ಚಂದ್ರನ್,
Yes,
ಮುನೀಶ್ ಶಾಮಪ್ಪ ಇವರೆಲ್ಲನ.
also.
Yes. ಆಯ್ತಾ?
Please.
Thank you. Yes, Mr. Vala, do you want to say anything?
Lord, can I seek one short accommodation because you ಏನು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರು ನನಗೆ ಫಸ್ಟ್ 2 ಗಂಟೆ ನಾನು ಇರ್ಲಿಲ್ಲ. Can I, sorry, my profound apologies.
All right.
14th ಹಾಕೊಂಡ್ರೆ ಅಥವಾ ಯಾವತ್ತ ತಮಗೆ ಯಾವತ್ತಾಗುತ್ತೆ ಅಂತ ತಾವು 18, 19 ನಾನು ಊರಲ್ಲಿರಲ್ಲ, ಅದನ್ನ ಬಿಟ್ಟು ಬೇರೆ ಯಾವತ್ತಾದ್ರೂ ನಾನು ಹಾಕೊಳ್ಳಿ ನಾನು ಬರ್ತೀನಿ. Because that endorsement also has been set aside by the
Post ಅದು
ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಅವ್ರಿಗೆ ಓದಿದ್ರಲ್ಲ BDA ಏನೋ ಅದು ಸೆಟ್ ಅಸೈಡ್ ಆಗಿದೆ. ನಾನು ತೋರಿಸ್ತೀನಿ, ಅದಕ್ಕೆ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲೇ ಇದೆ, ತೋರಿಸ್ತೀನಿ.
ಹೌದಾ?
ತೋರಿಸ್ತೀನಿ ನಾನು. ದಟ್ಸ್ ವೈ ಮೈ ಲಾರ್ಡ್ ಐ ಲ್ಯಾವ್ ಟು.
So when we sit next. ಯಾವಾಗ ಫೋನ್ ಬಂದಿತ್ತಾ? ಫ್ರೈಡೆ ದಿವಸ ತೋರಿಸ್ತೀನಾ?
ದಿಸ್ ಫ್ರೈಡೆ ಆರ್ ದ ನೆಕ್ಸ್ಟ್ ಫ್ರೈಡೆ?
ಅಲ್ಲ, ಇದೇ ಫ್ರೈಡೆಗೆ ಅಷ್ಟೇ ನಮ್ ಬೆಂಚ್ ಇರೋದು, ಸ್ಪೆಷಲ್ ಬೆಂಚ್. ಈಗ ಕೆಲವು ಯಾಕಂದ್ರೆ ನಮ್ 371 ಇದೆ, ಇದು ಒಂದೇ ಅಲ್ಲ, ಇದು ಆಲ್ರೆಡಿ ಅದನ್ನ ನಾವು ಎಂಟೈರ್ ರಿಕ್ರೂಟ್ಮೆಂಟ್ ಪ್ರೊಸೆಸ್ ಹಾಲ್ಟ್ ಮಾಡಿ.
No, I understand because ultimately my lord your lordship also must remember things. ನಾವು ಸುಮ್ಮನೆ ಮುದ್ದೆ ಹಾಕೊಂಡ್ರೆ ತಮಗೂ ಮರ್ತು ಹೋಗ್ಬಿಡುತ್ತೆ.
ಇಲ್ಲ, ಮರೆಯಲ್ಲ ನಾವು. ಏನು ಮರೆಯೋದಿಲ್ಲ. ಎಸ್,
ಅಲ್ಲ, ತಾವು ಮರೆಯೋದಿಲ್ಲ ಅಂತಂದ್ರೆ 21ಕ್ಕೆ ಹಾಕೋಬಹುದಾ ಅಂತ.
ಅಲ್ಲ,
ಯಾಕಂದ್ರೆ
ಇವ್ರು
14ಕ್ಕೆ
ಬರ್ಬೇಕಲ್ಲ. ಇವ್ರು
Oh,
ಬರ್ಬೇಕು.
ನೀವು ಇಲ್ವಾ?
ಅಲ್ಲಿ ಇವರು ಕಲಬುರ್ಗಿ ಇವರು.
Oh,
ಅಲ್ಲಿಂದ
I'm so
ಕರ್ಕೊಂಡ್
sorry.
ಬಂದಿವ್ರು.
My apologies, my lord. My apologies. I didn't.
He's
All
an
right,
imported judge.
all right, I'll be here. I'll be
They have
here.
imported
No,
him
no,
from
no, no, no.
Kalaburgi.
That
For,
I,
this
Lord, I
case,
forgot.
ಅಲ್ಲಿ ಒಂದು
I
ಮೂರ
forgot.
ಕೇಸ್ ಇದೆ ಅಷ್ಟೇ.
I forgot. Sorry.
Okay.
My apologies. I'll, my lord,
Please try.
ಖಂಡಿತ.
My apologies. No.
Huh.
But and according to my information, that is not set aside. But I'll also.
ನೋಡ್ಕೊಂಡು
Sir,
ಬಂದೆ.
I'm
ನನಗೆ
not
ಇಲ್ಲಿ ಇವ್ರಿಗೆ
aware.
that's why.
I should not be
No, no.
said
that's
that,
fine.
my lord, I
No, no.
suppress, I
I'm
am
not
not
saying-
aware.
I'm not
No,
saying-
no, nobody
I'm
will
not
make
saying-
that
nobody is
allegation
saying, my lord.
against
I don't, but I don't think, my lord, I have said that yes, suppress. ಗೊತ್ತಿಲ್ಲದೆ ಆಗುತ್ತೆ ಸ್ವಾಮಿ.
Nobody will make such allegation against you.
ಇಲ್ಲ,
Don't worry about it.
ಇಷ್ಟು ದಪ್ಪ ಇದೆ. ಇಷ್ಟು ದಪ್ಪ ಇದೆ, ಇದ್ರೊಳಗೆ ನಾನು ಎಲ್ಲಿ ಇದ್ದೆ ನೋಡು. ಅವ್ರನ್ನ ನೋಡಕ್ ಆಗಲ್ಲ. But these things happen. I'm not.
But he is a very efficient and one
No,
of
no, no,
the
but that's what-
very efficient
Correct.
panel advocates of BDA.
Yes, definitely.
Yes.
Obliged.
Ah. No.
I think they're acceptable to, subject to what your lordships may.
He has served me a copy. I
Ah.
will file my written.
Written submission ಹಾಕ್ತೀರಾ?
ಅದು ನಮ್ದು ready ಇದೆ. I don't know about my.
ನಮ್ಗೆ ಇನ್ನೊಂದು ಪಾರ್ಟ್ನರ್ ಮ್ಯಾಟರ್ ನಲ್ಲಿ ಇದೆ, ಏನಾಗಿದೆ 371J ನಾವು ಹಾಲ್ಟ್ ಮಾಡ್ಕೊಂಡು ಕುತ್ಕೊಂಡ್ಬಿಟ್ಟೇವಿ ಈಗ. ಅದ್ರ ಮೇಲೆ ಬೇರೆ ಎಲ್ಲ ರಿಕ್ರೂಟ್ಮೆಂಟ್ ನಿಂತ್ಕೊಂಡು ಹೋಗ್ತದೆ. ಹಾಗಾಗಿ
I think it would be most advisable, most convenient to the court also. Our written submissions are ready. Same thing, let it put it in writing.
ಈಗ ಅವತ್ತು ಆರ್ಗ್ಯೂ ಮಾಡಿ ಆಗಿದೆ ನಿಮ್ದು ಹಿಂಗೆ ಅಂತ, ಬಟ್ ಅದ್ ಬಿಟ್ಕೊಂಡು ಹೊಸದ್ ಏನಾರ ಮಾಡೋದಿದೆಯಾ? ಆಯ್ತು, ಫ್ರೈಡೆ ಹಾಕೊಳ್ತೀವಿ, 2 ನಿಮಿಷ ಮುಗಿಸ್ಬಿಡ್ಬೇಕು ಅವತ್ತು. ಯು ವಿಲ್ ಗೋ ಟು ದಿ ನೆಕ್ಸ್ಟ್.
Written ಇದ್ರೆ ಅವತ್ತು
ಅಷ್ಟೇ ಫ್ರೈಡೆ.
Can we submit our written?
Huh?
submission?
ಹೇಳಿ. ಫ್ರೈಡೆ ಪ್ಲೀಸ್. ಆಯ್ತು, ಫ್ರೈಡೆ ಬರ್ತಾರೆ.
Our written submission, give it now only.
ಬೇಡ, ಅವ್ರು ತಿಳ್ಕೊಂಡು ಆಮೇಲೆ ಚೇಂಜ್ ಮಾಡಿಕೊಡಿ. ಅವ್ರೇನ್ರ ಹೊಸ ಪಾಯಿಂಟ್ ಹೇಳಿದ್ರೆ ಅದು ಹಂಗ ಉಳಿಯುತ್ತೆ ಅದಕ್ಕೆ. ಓಕೆ,
Great.
ಯಾವ್ದ್ರಿ ಮತ್ತೊಂದು? ಹಾ, ಇಬ್ರು ಸೈನ್ ಮಾಡಿಕೊಟ್ಟಿರಾ? ನೀವು ಮಾಡಿರಾ?
ನಾನು ಮಾತ್ರ ಮಾಡಿ. ಪೆಂಡಿಂಗ್ ಇರಲಿ.
ನಿಮ್ಗೆ ಅಗ್ರಿಯೇಬಲ್ ಇದೀರಾ ಅದಕ್ಕೆ?
for which we.
ನಿಮ್ಮ ಕ್ಲೈಂಟ್ ಓದಿದಾರನ ಅದನ್ನ?
ಅವ್ರ ಮುಂದೆನೆ ಬರ್ದಿದ್ದೀನಿ.
ಕೊಡಿ ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ.
It is very nearby to his house.
ಒಂದ್ಸರಿ ಓದಿ.
Lord, sorry, the respondent number 1 above named humbly submits that pursuant to the order dated 28/11/2024 passed by this honorable court, the BDA is unable to convey the site number 1814 Nadaprabhu Kempegowda layout as it has already been allotted to Sri C.T. Venkatappa. In lieu of the said site, BDA can allot site number 2077 8th block Sir M. Vishweshwaraya layout measuring 12 into 18 meters. Accordingly, the applicant would be liable to pay a sum of ₹7,19,320 towards the additional area of 158 square feet. Wherefore, it's most humbly prayed that this honorable court may kindly be pleased to modify the order dated 28/11/2024 and pass necessary orders in the interest of justice and equity.
ಅಲ್ಲಿ ಹೋಗಿದ್ಯಾ? Anyway, all right. No problem. By your order dated 19/12/2024, we had said as. This day, matter was again heard for some time. And learned counsel, senior panel counsel appearing for the BDA has filed memo dated 12/3/2025.
I'm sorry, my lord. I had also filed another memo earlier recording the proceeding sheet of the BDA, my lord. That may also be taken on record, my lord, in the order. In the morning, I had given it. That has the signature of the commissioner, my lord, approving this and seeking the orders of your lordships.
dated 12/3/2025. 25. Seeking leave of the court to place on record a copy of note sheet. Correct, huh?
Please, my lord.
Note sheet. More particularly, note 17, huh?
Note number 65, my lord.
Huh?
Note number 65 to 71.
Note number 65 to 71, which read as under. ಹೌದು. ಮತ್ತೊಮ್ಮೆ introduce ಮಾಡ್ಕೊಂಡು ಮತ್ತೆ ನಾನು ಹೇಳಿಲ್ಲ ಮಾಡಿಲ್ಲ ಅನ್ನೋದು ಬೇಡ. ಬರ್ಕೊಳ್ಳಿ. He has also filed another memo in furtherance of the note sheet.
Please, my lord.
This day, which reads as under. First off. This will be an undertaking of the BDA that you will allot site and
Yes, my lord, it is already,
it's all we have recorded it.
yes, yes.
ಬರ್ಕೊಳ್ಳಿ. The contents of the order sheet, note sheet, followed by the second memo, are to be construed as an undertaking given to this court and to the petitioner, appellant. Correct? Appellant. First off, learned panel counsel assures the court that the in terms of the above development, the order dated 28/11/2024 needs to be marginally modified by substituting the site indicated in the two memos filed today in lieu of earlier one. First off, we agree with this. Since the appellant has also no objection for this course of action. First off. Accordingly, the order to that extent stands modified.
May I request your lordship to kindly, there are two sites in the earlier order. Only one site, my lord, gets replaced with this. The other
Correct.
site will continue, my lord.
Alle. Correct. In terms of this one, na?
Yes.
So that will, it is made clear that out of the two sites mentioned in the order dated 28/11/2024, comma, substitution is confined to only one of them,
One site bearing number 1814.
which is mentioned in the memo.
Please, my lord.
The memo and the note sheet.
Please.
Note sheet. First off. Panel, the learned counsel on the instruction of the appellant submits that his client would make a differential payment indicated
In the memo.
in the second memo.
Yes, my lord.
In the second memo. First off. Learned panel counsel for the BDA submits that once that amount is remitted by the appellant, comma, both the sale deeds in respect of both the sites shall be executed within 1 week thereafter.
Please, my lord.
Thereafter. First off, we appreciate this fair stand. Subject to the rider that all this would be treated as an undertaking given to the court, violation of which may result into some penal action, which may include imprisonment at the hands of this court itself. Okay. Next paragraph. Call this matter on 24th.
May I request one thing, my lord?
ಬರ್ಲಿಲ್ಲ. Within 1 week ಕೊಟ್ಟೇವೆ ನಾವು ನಿಮ್ಗೆ ಅದಾದ್ಮೇಲೆ ಅವ್ರು ನೀವು ದುಡ್ಡು ಯಾವಾಗ ಕೊಡ್ತೀರಿ?
Next week.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಕೊಡ್ತೀರಾ? ಕಾಲ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 2nd of April.
Lordship may kindly,
Ah.
Lordships may, if I may request Lordships to specify a timeline within which PDA will execute the sale deed after the payment of the money, so that my lords, there is
Wednesday I
In
will.
1 week ಅಂತ ಬರ್ದೇವಲ್ಲ?
1 week from the payment ಆದ್ಮೇಲೆ.
Correct.
Please, my lords.
ಓದಮ್ಮ. ಅದಕ್ಕಿಂತ ಮೊದಲೇ. Executed and registered within 10 days
Please, my lords.
after such a payment.
Greatly obliged. Greatly.
After such payment. Okay. ಮತ್ತಿದು ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ we
ಇಲ್ಲ.
have said
ಮಾಡ್ಕೊಡ್ತೀವಿ.
something will happen.
Tell.
Tell
will
tell
complete.
your commissioner.
We will comply with it, my lords. Obliged, my lords.
Call on 2nd of April. 4th of April. All. 4th of April.
Obliged.
All.
Much obliged.
Yes. ಇದೆ. ರೆಂಟಲ್ ಅಮೌಂಟ್ ಎಲ್ಲ ತುಂಬೋದಿತ್ತಲ್ಲ ಅದ ಇದು?
ಹೌದು.
ಪೇಮೆಂಟ್ ಮಾಡಿದಾರಾ?
My lord, after the interim order, they have paid once in Jan start and no further payment in Jan, no
Then I'll
further
not
payment
appear.
in Feb.
My lord, then
ಆರ್ಡರ್ ಮಾಡಿ.
And that too, my lords, when we reiterated that order passed by this honorable.
Payment ಮಾಡಿದ್ರು.
ಯಾವಾಗ ಮಾಡಿದ್ದಾರೆ?
ಆರ್ಡರ್ ಕೊಡಿ. ನಮ್ಮ ಆರ್ಡರ್ ಕೊಡಿ.
1 minute I say, forget about now. ಈಗ ಮಾಡಿದಾರ ಅಂತ.
ಮಾಡ್ತಾರೆ.
My lord, ಕೊಡಿ ಅದನ್ನ ಮತ್ತೆ.
Proposal of this
I don't know. Memo type ಮಾಡ್ಲಿಕ್ಕೆ ಆಗೋದಿಲ್ಲ. ಸರಿಯಾಗಿದ್ದಾರೆ, ನಾನು I will not appear.
in order to continue subject to the limited
ಎಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ?
arrears
ಅವ್ರ
being paid
November 2025
on regular basis.
Has it been paid now? It has been paid ಅಂದ್ರೆ?
ಈ ರೆಗ್ಯುಲರ್ಲಿ ಅಕ್ರೂವಲ್ ಆಗೋದೇನಿದೆ ಅಲ್ಲ, ಈ ಉಳಿದಿದ್ದು ಏನ್ ಡಿಸ್ಪ್ಯೂಟ್ ಇದೆ ಅದನ್ನ ಬಿಡೋಣ.
ಅದೇ
ರೆಗ್ಯುಲರ್ಲಿ ಏನ್ ಅಂಡರ್ಟೇಕಿಂಗ್ ಮಾಡಿದ್ರಲ್ಲ ಕೊಡ್ತೀವಿ ಅಂತ, ಅದನ್ನ ಕೊಟ್ಟಿದ್ದನ್ನು ತೋರಿಸಿ ಕೊಡಿ. ನಾಟ್ ಪೇಡ್.
Not paid.
ನಾಟ್ ಪೇಡ್.
8 crores and orders.
ಅಲ್ಲ, ಅದು ಹಿಂದಿನ ಡಿಸ್ಪ್ಯೂಟ್ ಬಿಡಿ, ರೆಗ್ಯುಲರ್ಲಿ ಕೊಡುವಂತದ್ದು ಕೊಡ್ಬೇಕು ಅಂತ ಹೇಳಿದ್ವಲ್ಲ, ಅದೆಷ್ಟಾಗ್ತದೆ?
ಅದು minimum amount, Swami.
that has been paid, my lord. Please look at their own statement here.
Well,
Every month it's being paid.
No, my lords, it is.
not paid.
I'll explain, my lord. My lords,
Yes.
on this third page of the sheet given, my lords.
What is the monthly payable according to
My
you?
lord, monthly payable is 22,76,717.
When we made the order to make the payment?
My lord, the order.
December, my lord.
12/12/2024.
My lord.
ಅವಾಗ ಅಲ್ಲಿಂದ ಯಾವ ಡೇಟ್ ಅನ್ನು ಕವರ್ ಆಗತ್ತದು?
ಡಿಸೆಂಬರ್ ಒಂದ್ ಬರುತ್ತೆ, ಜನವರಿಗೆ ಒಂದ್ ಬರುತ್ತೆ, ಫೆಬ್ರವರಿಗೆ ಒಂದ್ ಬರುತ್ತೆ.
ಡಿಸೆಂಬರ್, ಜನವರಿ, ಫೆಬ್ರವರಿ
3 ಬರುತ್ತೆ.
Do you have a
ಬರ್ತದೆ.
receipt?
67 ಲಕ್ಷ ಪ್ಲಸ್.
Then, ask them to appear themselves.
67 lakhs not paid.
They have
Lord.
paid 20 lakh, my lords.
20 lakhs.
ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ?
Consolidate ಮಾಡಿ ಇಷ್ಟು.
Forget about consolidated. What is the amount that you have paid?
ಅವ್ರಿಗೆ ಒಂದು ಕಾಪಿ ಕೊಡಿ. ಅವ್ರು ಕೊಟ್ಟಿದ್ದ ಇದೆಲ್ಲ ಚೆಕ್ ನಿಂದನೇ ಪೇಮೆಂಟ್ ಆಗ್ತದೆ. ಏನಿದೆ
Okay.
ಕ್ಯಾಶ್ ನಲ್ಲಿ ಆಗಲ್ಲ, ಏನಿದೆ.
ಆಯ್ತು,
ಅವ್ರು
anyway, not-
share a copy with you.
Same bench is sitting on Friday. ನಾನು ಇದು ನೋಡ್ಕೊಂಡು ಹೇಳ್ಬಿಡ್ತೀನಿ.
All right.
Friday ಮಾಡ್ಬಿಡ್ತೀನಿ.
Friday, if payment is
ಅದನ್ನ
not
ಮಾಡದೇ
made,
ಇದ್ರೆ ಕೊಡ್ಬೇಕಾಗತ್ತೆ.
then
My lord,
tell
I-
your client that we will make
Naturally.
adverse order.
Correct, natural.
Yes.
Day after tomorrow.
Isn't it good? Noಡ್ಲಿ.
Learned
ನೋಡ್ಲಿ.
panel counsel and the OL Shri so and so notified to the court that in terms of the order dated 12/12/2024, only a part payment is made, and there is a huge amount standing due in disregard of the said order. First, learned senior advocate Mr. Holla wants to confer with his client and come back. First off, call this matter on Friday. First off, we make it clear that in the event the amount in terms of our order is not paid, is not shown to be paid within the time specified already, comma, adverse order may follow. Please, against the appellant, petitioner.
Appellant.
Appellant company, yes. ಅಂತ ಹೊತ್ನಲ್ಲಿ ಏನೆಲ್ಲ ಅಡ್ವರ್ಸ್ ಆರ್ಡರ್ ಮಾಡ್ಬೋದು? ಕ್ಯಾನ್ ವಿ ಡೈರೆಕ್ಟ್ ಟೇಕಿಂಗ್ ಪೊಸಿಷನ್?
Please, my
ಎಲ್ಲ
lord.
ನೋಡ್ಕೊಂಡು ಹೇಳ್ಬೇಕು ಸ್ವಲ್ಪ.
Please, my lord.
ಓಕೆ.
This is
ಹೌದು,
the-
ಇಲ್ಲಪ್ಪ ಅಂದ್ರೆ ಅವರು ಹಂಗೆ ಅಂಡರ್ಟೇಕಿಂಗ್ ಮಾಡಿದ್ಮೇಲೆ ಅವರೆಲ್ಲ ಎಂತ ಜನ ಇವ್ರು ಕಂಪನಿಗಳು. ಎಸ್. ಎಸ್, Mr. Chandrasekhar, we made you wait for long.
May I just make one submission before learned senior starts?
Yes.
But I appear for some of the respondents in this matter. I'm being led by Dr. Sondi, my lord. Unfortunately, is not in the country this week, my lord.
ನಾವು ಯಾವುದು ಹಾಲ್ಟ್ ಮಾಡಲ್ಲ, ಅವ್ರನ್ನ ನಾವು ಕರ್ಸ್ಕೊಂಡೇವಿ. ಇಷ್ಟೊತ್ತಿಗೆ ಕೂಡಿಸಿದ್ದ ಫಸ್ಟ್ ವಿ ಶುಡ್ ಹಾವ್ ಟೇಕನ್ ಔಟ್ ಆಫ್ ಟರ್ನ್. ಬಟ್ ಎನಿವೇ ಟೈಮ್ ಬೌಂಡ್ ಇಂದ ಎಷ್ಟೋ ಆರ್ಡರ್ಸ್ ಆನರಬಲ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್, ಹಂಗಾಗಿ ಲೆಟ್ ದೆಮ್ ಸ್ಟಾರ್ಟ್.
Please, my lord. AG also has to complete thereafter. After that, kindly accommodate.
We do not know. ಯಾರು whoever wants to come and argue, most welcome.
Kindly
But
accommodate us.
no question of accommodation. Let us see. No question of accommodation. ನಾವು ಬೇರೆ ಟೈಮ್ ಕೊಟ್ಕೊತ ಹೋಗ್ಬೇಕಾಗ್ತದೆ ಜನರಿಗೆ. ನಮ್ ಕೆಲಸ ಮಾಡೋದೇ ಅವಾಗ ಜನ ಎಲ್ಲ ನೋಡ್ತಿರ್ತಾರೆ. ನಮ್ ಇಷ್ಟೆಲ್ಲ ಮಾತಾಡ್ತೀರಿ, ಭಾಷಣ ಮಾಡ್ತೀರಿ, ಏನ್ ಕೆಲಸ ಮಾಡ್ತೀರಿ ಅಂತ ಕೇಳಿ ಏನ್ ಹೇಳೋಣ ನಾವು ಉತ್ತರ?
Only difficulty was we were only intimated yesterday. ಅದಕ್ಕೆ ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ.
Please. Yes, start.
On the last occasion, my lord,
Yes.
I brought, just to recollect, my lord, what I argued, my lord, on the last date of hearing. I brought to the notice of the court, my lord, the report submitted by the state government made a request to the parliament to make an amendment. And the reports indicating, my lord, the statistics where there is a disparity, my lord, with the
Dr.
Hyderabad,
Nanjundappa
Karnataka.
report and other.
Yeah, the statistics of Nanjundappa's report also, my lord, I brought to my lord's. And thereafter, my lord, a glance at 371J, my lord, not in detail, my lord, which I will propose to do it, my lord, later. Only to show, my lord, that it is not the same as 371D
Of Andhra Pradesh.
of Andhra Pradesh. Much reliance was placed, my lord, by the petitioners' counsel, my lord. The judgment, because it is a old, my lord, provision under the constitution, which had the similar impact, my lord, and the object was also similar. There is no comparison with the, my lord,
D-
371J. No reliance can be placed, my lord, blindly, my lord, to those
Agreed.
of the judgments rendered by the
Under
Andhra Pradesh High Court and, my lord, the apex court. That was my endeavor, my lord, to show. Because your lordship may recollect, my lord, in 371D, my lord, the entire state was divided into regions. My lord, the regions, my lord, were given, my lord, the separate cadre, my lord, in the region. And there was no question of, my lord, jumping, my lord, from one region to the other region. Whereas in this case, my lord, there is no such, my lord, there are only two, my lord, Hyderabad, Karnataka region and the rest of the state. And there was no embargo, my lord, in the 371J, as well as, my lord, the order made by the governor, my lord, in 2013. Therefore, my lord, there was a restriction.
ಆ analogy ಇದಕ್ಕೆ apply ಆಗಲ್ಲ.
ಆಗಲ್ಲ.
Let senior advocate Mr. Chandrasekhar sir.
Last time ಬರ್ದಿರ್ತಾವ.
ಬರ್ದೇವಿ. Anyway, just now,
Yes,
begin
yes,
with that.
yes, yes.
There is a huge textual and content difference between 371D applicable to Andhra Pradesh and Article 371J applicable to our state. Semicolon. Because of that difference, comma, the decisions rendered under the former would not much throw light on the text and context of content and scope of Article 370 on the later.
I have also relied upon, my lord, the presidential order, my lord, as far as 371D is concerned, where, my lord, a similar provision with reference to, my lord, the circular in question, wherein, my lord, it is stated that the residuary cadre will be considered first and thereafter reserved category. With reference to the notification.
371D.
371D presidential order, my lord.
Correct.
Here it is a governor's order, my lord. The entire mechanism is, my lord, based on the order 2013 order issued by the governor in exercise of the power, my lord, conferred by the president under 371J. My lord, in that one of the, my lord, the presidential order, there is a reference, my lord, how it has to be treated. The merit, a person in the residuary cadre and a person in the reserved category cadre. It is stated that the reserved category will be considered later. A person who has a merit will be considered, my lord, in the residuary cadre.
Then the reverse of 371D.
371D, one order is there.
Similar.
Similar, my lord. I brought to my lord's notice.
ಅದು ಕಂಪೈಲೇಷನ್ ಇತ್ತಲ್ಲ ಅವ್ರದ್ದು ಆಲ್ ಆರ್ಡರ್ಸ್ ಕಂಪೈಲ್ ಮಾಡಿ ಕೊಟ್ಟಿದ್ರಲ್ಲ ಅದು ಕೊಡಿ.
ಹಾ ಒಂದು ಇಲ್ಲ ಅವ್ರು ಕೊಟ್ಟಿರೋ ಜಜ್ಮೆಂಟ್ ಅಲ್ಲೇ
ಡಿವಿಷನ್ ಬೆಂಚ್ ಆಫ್ ಆಂಧ್ರ ಪ್ರದೇಶ್ ಹೈಕೋರ್ಟಾ?
ಹೌದು. ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಜ್ಮೆಂಟ್ ಅದು.
ಅಲ್ಲಿ ಮಧು ನಾಯ್ಕರು ಮತ್ತ ಲಕ್ಷ್ಮೀನಾರಾಯಣ ಅವ್ರು ಕೊಟ್ಟಿದ್ದು ನೋಡಿ. MR ನಾಯ್ಕ ಕೊಟ್ಟಿದ್ದು ನೋಡಿ. ಮಸೂದ್ ನಾಯ್ಕ
ರೂಲ್ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡಿ.
ರೂಲಿಂಗ್ಸ್ ಒಂದು
ಜಜ್ಮೆಂಟ್, my lord, is
ನಮ್ದು ಅಂತ ಹೇಳ್ರಿ.
1991 Supreme Court, Volume 2, my lord, 367.
ಹೆಸರೇನದು?
My lord, Government of Andhra Pradesh and others versus Suryanarayan Rao.
ಸೂರ್ಯನಾರಾಯಣ 181, 197, 181.
191. Supplement, Volume 2.
Correct.
ಇದಲ್ಲ.
ಇಲ್ಲ ಅವರು ಕೊಟ್ಟರು.
Yes, sir.
Paragraph. But there's some confusion, my lord.
ಒಂದು DP ಜಜ್ಮೆಂಟ್ ಇತ್ತನು ಅಂತ ಚಂದ್ರಶೇಖರ್ ಅಲ್ಲಿ ಇದರಲ್ಲಿ ಆಂಧ್ರದಲ್ಲಿ ಈ ರೆಫರ್ ಟು
I think you will refer to last time Suren Reddy case.
Can I just point out later, my lord?
All,
I've just.
all. Huh? All.
There is one paragraph, my lord, where, my lord, it says merit must be considered first and thereafter, my lord, the reserved category. It's only for that limited purpose. My lord, the contention, my lord, of the petitioner, my lord, in this case throughout, my lord, all of them, my lord, contended. The Indra Sahni's judgment, my lord, where the Honorable Supreme Court, my lord, have stated a person coming from a reserved category is entitled to compete against a general merit category. If he is selected from the general merit category, the post that he is occupying will not be counted against the reservation, my lord, of their quota.
Because he comes from the open market.
Therefore, my lord, their contention is that principle cannot be made applicable to 371J. They have their own quota. They must compete in their own quota. There is no such contingency to allow them to participate in a general merit non-residuary cadre, drawing the sustenance from the Indra Sahni's case. My contention is, my lord, Indra Sahni's case, my lord, is a universal application of that principle of everybody is entitled to compete against the general merit quota. If he is not successful in competing, getting a seat,
He may come to this one.
yes,
If
that
he
is a
succeeds-
universal principle. Incidentally, my lord, it has been stated in Indra Sahni's case. Drawing the, my lord, that analogy, there is a presidential order under 371D, which also speaks of this concept of allowing a non-reserved, reserved candidate to compete against a reserved category. And if he is not successful, he can go back to the reserved
General.
category. Therefore, it is not flowing from Indra Sahni's case. It is a universal application of, my lord, this principle.
That is-
Otherwise, it amounts to imposing a restriction on a reserved category to compete in a general merit pool.
That's not the object of that government.
Yes, my lord, is my respectful submission. Even, my lord, the Honorable Supreme Court, their lordship in Ravindra Bhattor, there is no quota as general merit quota. General merit quota is not a quota. It is open.
Open market.
Everybody is entitled to compete against the open.
Including those who belong to scheduled caste, scheduled tribe, or special
Whatever category.
category.
Whatever category.
They can be competitors, they can be in the fray,
Yes.
although reverse is not true.
No.
But once they are selected in general, in the open market,
Yes.
they will get selected. If they do not, they come to reserve category.
Yes. This is one aspect, my lord. The other contention is that it is a horizontal reservation. The Supreme Court judgment says, my lord, in case of a horizontal reservation, if you have already occupied the number of posts, if you are selected, the reserved candidate is selected in a horizontal reservation.
But Salpa, what is vertical reservation? What is horizontal? Salpa helbdi.
Last time I heard that.
ಒಂದು 2-3 ಸೆಂಟೆನ್ಸ್ ನಲ್ಲಿ ಹೇಳ್ಬಿಡಿ. Yes.
When it comes to Article 16, my lord, it is a vertical reservation. The reservation provided under Article 16 will fall, my lord, in the ambit of a vertical reservation. All those reservation other than the social reservation or a backward class reservation. There can be a reservation of women reservation, physically handicapped reservation.
Soldiers quota. Yes,
All
yes,
these
yes.
other than the social reservation, my lord, under 16(4). Either they fall under 15 or they may fall under 16(1). If the quota is satisfied as far as the horizontal is concerned, irrespective of the quota, irrespective of where he is selected, once that quota is filled up, For example, 10 posts are there in the horizontal reservation. If a scheduled caste physically handicapped person is there, if he is selected in a horizontal quota, the quota that is occupied by horizontal reservation is counted as far as 10 is concerned.
As far as that cadre strength is concerned.
As far as that reservation of 10% for that particular category of horizontal is concerned, whoever may fall under horizontal reservation, he can be a candidate, woman candidate, he can be a Kannada rural, or it can be a physically handicapped, ex-serviceman, whatever category. Once that quota of 10 is filled up, that is counted irrespective of who falls under that horizontal quota. That quota is filled up. There cannot be a 11th person in that horizontal reservation. So they would like to draw the analogy of horizontal reservation and say, once this 75%, 80% quota is filled up, you cannot have the 76th person. Therefore, it is a horizontal reservation is the contention of some of the petitioner. My contention is, my lord, it is neither horizontal nor vertical. It is a separate reservation. It is not falling within the ambit of 14, 15 or 16.
That's the
Those
very object of
principles,
371.
Lord, enunciated in those judgments cannot be pressed into service as far as 371J is concerned.
It's a very unique
Yes.
provision.
Yes, it is a regional classification. Reservation is on the basis of regional classification. Therefore, the provisions of Article 15 or 16 is not applicable. The judgment of the Supreme Court rendered, my lord, on this horizontal and vertical reservation.
They do not come to their aid.
Yes.
In other words, Article 371J does not admit the conventional concepts of reservation at all.
Yes.
Article 371J being unique by its very nature and region specific, the conventional concepts of reservation in general, horizontal and vertical in particular, stand alien to the field.
No reliance can be placed on the
Therefore, any decision rendered on the conventional concepts would not come to the aid of petitioners.
Constitutional reservation.
371 also will be a constitutional reservation. Again, we will be falling into the trap. I am specifically saying, my lord, Article 15 and 16.
First of all, he clarifies that, he adds that the conventional reservation in the context means those that fit into Article 15 and Article 16(1). 16. ಯಾಕಂದ್ರೆ 4A, 4B
Lord, my lords wanted to know, my lord, to explain, my lord, vertical reservation and horizontal reservation. My lord, I just straight away go to, my lord, the judgment rendered by the Honorable Supreme Court. My lord, in a very short paragraph, my lord, it has been stated in the case of Saurav Yadav.
2021 ACC 5. Violation page number is.
Ravindra Bhatt and
Justice Uday Lalit and
Maheshwari Sahibaru idarna?
ಇಲ್ಲ. And Justice Hari Roy.
Rishikesh Roy.
Rishikesh Roy. Lord, I am reading, my lord,
Page number?
Page number 184 of the paper book, my lord, index.
Judgment the page ಹೇಳಿ.
Judgment page, my lord, 752, my lord, page number 752.
542,
Hmm,
2021 4 SCC.
Other, of course, depends upon which citation ಮೇಲೆ.
SCC online.
SCC online. ಇದು SCC regular ಇದು 4 SCC 2021 4 SCC. Paragraph ಹೇಳಿ.
Para 59, my lords. Page 184, my lord. The index page. ನಮ್ದೇ ಕೊಟ್ಟಿದ್ದಾರೆ.
15.
Top of the page, my lord, on the right hand side of the each page, my lord, is the index page.
Page
Printed index
180
page,
184
184, my lords.
paragraph
59, my lords.
59, you are right. The features of vertical
Features of
reservations
vertical
are-
reservations are, they cannot they cannot be filled by open category or the categories of the candidates other than those specified and have to be filled by a candidate of social category concerned only. The mobility, migration from the reserved specified category to the unreserved open category slot is possible based on the meritorious performance. In case of a migration from a reserved to the open category, the vacancy in the reserved category should be filled by another person from the same specified category lower in rank. If the vacancy cannot be filled by a specified category due to the shortfall of a candidate, the vacancies are to be
The
treated.
59.3 is reiteration of ಇದು ಮಂಡಳ.
ಹೌದು. ಇಲ್ಲಿ ಶಾರ್ಟ್ ಆಗಿ ಕ್ರಿಸ್ಪ್ ಆಗಿ ಹೇಳಿದ್ದಾರೆ.
ಹೇಳ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅಂತ. You are right. If the vacancy cannot be filled by the specified category due to shortfall of candidate, the vacancy are to be carried forward. Signs. Horizontal
This-
reservations on the other
This
hand.
becomes important, my lord. If the reserved category candidate is not available, it cannot be filled by any other candidate. It will be
has to
carried
be by
forward.
it will be carried forward.
It carry forward.
But horizontal ಅಲ್ಲಿ ಹಂಗಿಲ್ಲ ಅಂತ.
ಇಲ್ಲ, ಅದು ಕೋಟಾ ಫಿಲ್ ಆದ್ರೆ ಮುಗಿದೋಯ್ತು ಅದು.
ಮುಗಿದೋಯ್ತು.
ಇಲ್ಲ ಅಂತಂದ್ರೇನು ಮುಗಿದೋಯ್ತು.
On the other hand, by the nature or para 60 ನೋಡಿ.
ಹೌದು.
Not in
The horizontal reservation and by their nature are not inviolate pools and carved in stone. They are
remind of
permissive
their
on their overlap and
Standard
overlocking
overlocking.
reservation. As a sequel, they are to be calculated concurrently along with the involved vertical or reservation quotas by application of various steps laid down, which clearly in para 21.3 in Lalit J judgment. They cannot be carried forward. The first rule that applies to fill the horizontal reservation quota is one of adjustment, examining whether on merit or on any other horizontal categories are adjusted in merit list in the open category. And
Then
when the quota for such horizontal category is within a particular specified social reservation. Now, this is important, my lord. Open category
is not a quota.
is not a quota. Open category is not a quota, but rather available to all women, men alike. Similarly, as held in Rishikesh Kumar Dharia, there is no quota for men. If we are to accept the second view, as held by the Allahabad High Court in IS so and so, so on, so on, referred in paragraph number so and so, Lalit J judgment, the result would be confining the number of women candidates irrespective of their performance in their social representation categories and therefore destructive of the logic
and
merit. And the second view, therefore, perhaps unconsciously support, but definitely result in confining the number of women in the select list to the overall number of quota assumed by the rule.
Similarly, page number 58.
Second view collapses completely. So therefore, second view, they do not agree.
Yes.
When more than stipulated percent.
Para 65.
The most meritorious category. The said second
65 and
view
66.
This merit, principle of mobility and migration.
Para 65 and 66. In view of this decision, it is too late in the day for the respondent state to contend that the women candidate who are entitled for the benefit of social category reservation cannot fill up open category vacancies. The said view strictly opposes as misconceived because it would result in
Women
such women candidate
Yes,
with less merit being selected and those with more merit than the such candidate left out of this election. I would conclude by saying that the reservation, both vertical and horizontal, are the method of ensuring the representation in public service. Those are not to be seen as the rigid slots where a candidate merits which otherwise entitle her to be shown in the open general category is foreclosed. As a consequence would be, if the state's argument is accepted, doing so would result in communal reservation where each social category is confined within the extent of their reservation, thus negating the merit. Then the open category is open to all, and only the candidates for the condition for the candidate to be shown in its merit, regardless of whether reservation benefit to her or him.
This is the larger view of the court.
Yes, yes. Concurring, my lord, my lord,
It
this is
becomes the
separate.
view of the
Yes,
court
yes,
only.
yes.
ಎಲ್ಲಿಂದ ಯಾವ ಪ್ಯಾರಾಗ್ರಾಫ್ ಇಂದ ಬಿಗಿನ್ ಆಗ್ತದೆ ರವೀಂದ್ರ ಭಟ್ ಸಾಹೇಬ್ರದ್ದು that is page one, internal page 179 para 50
Paragraph 15 start ಆಗಿದೆ.
594 ನಿಂದ
ಹೌದು. ಅಲ್ಲಿ ಬರೀತಾರೆ ಸಪ್ಲಿಮೆಂಟಿಂಗ್.
supplementing view
ಹೌದು.
ಅಂತ ಹಂಗಾಗಿ it becomes view of the bench itself.
Yes. It can be said it is not a minority view.
Of course.
Lord, page 59, may I request your lordship kindly? Rajesh Kumar Dharia.
Page 15 running page.
Yes. 58, my lord, page number 58. Lord, this is again by three honorable judges, my lord. K.G. Balakrishna, Ravindran, and Dalveer Bhandari. My lords will get at page 53, my lord. This is the third judgment, my lord, in the compilation given.
Yes, you are right. Rajesh Kumar Dharia.
Yes.
Ah.
Para
What it
9,
says.
paragraph 9, my lord. The second relates to a difference between the nature of vertical reservation and horizontal reservation. Social reservation in favor of SC. My lord, sir.
Yes.
My lord Justice Joshi, my lord. Yes. The second relates to difference between the nature of vertical reservation and horizontal reservation. Social reservation in favor of SC, ST and OBC under Article 16(4)
Or vertical.
vertical reservation. The special reservation in favor of physically handicapped women, etc. under Article 16(1) and 15(3) or horizontal reservation. Where a vertical reservation is made in favor of backward classes under Article 16(4), the candidate belonging to such backward class may compete for non-reserved post, and if they are appointed to non-reserved post in their own merit, their number will not, kindly mark this, my lord.
Their number
Their
will not be
number will
counted
not
against
be
the quota
counted against
reserved
the
for.
quota of reserved.
Because he becomes a general merit candidate ಆದಂಗೆ ಆಗಿಬಿಡ್ತಾನೆ ಎಲ್ಲಾ ದೃಷ್ಟಿಯಿಂದ ಅಂತ.
ಅದೇ ಹಾರಿಜೆಂಟಲ್ ನಲ್ಲಿ ಆಗಲ್ಲ.
ಆಗಲ್ಲ. ಅದು ಫಿಲ್ ಆದ್ರೆ ಮುಗಿದು ಹೋಯ್ತು.
ಅದು ಮುಗಿದೋಯ್ತು. I will give an example, my lord.
Yes.
Scheduled caste women. There are 10 posts. The competitors are 25. 25 women scheduled caste. all that 10 post is exhausted. Just because 10 post horizontal reservation for women is there. For example, in that 10 post of women, my lord, 4 SC, 2 general merit candidates, all put to them become 10. The 11th person will not get.
Exhausted.
Exhausted. Quota is exhausted. Whereas it is not so, my lord, in case of the general merit category. Up to whatever the posts are available, they will be competing, irrespective whether they are general merit category or scheduled caste or scheduled tribe or backward class category.
It's open market,
It is an open market.
open to everybody.
Open to everybody. They can be beyond their, I mean, up to the quotas, up to the vacancies available, my lord, in the general merit category. Therefore, if the number of SC candidates who by their own merit get selected in the open competition vacancies equal or even exceeds the percentage of posts reserved for SC candidate,
ಹಂಗಾಗಿ ಆ ಪೋಸ್ಟ್ ಫಿಲ್ ಅಪ್ ಆಗಿದೆ ಅಂತ ಅನ್ಲಿಕ್ಕೆ ಬರೋದೇ ಇಲ್ಲ.
ಅನ್ನಕ್ಕೆ ಬರೋದಿಲ್ಲ. You have already occupied SC quota. Therefore, 18% is been complied. You cannot come and ಹಂಗ ಅನ್ನಕ್ಕೆ ಬರಲ್ಲ.
Because on merit ಬಂದಿರ್ತಾರ ಕ್ಯಾಂಡಿಡೇಟ್.
But general merit ನಲ್ಲೂನು physically handicapped women.
ಬರ್ಬೋದು. ಬರ್ಬೋದು.
ಅದು ಬರುತ್ತೆ.
ಅದು ಬರುತ್ತೆ. ಬಟ್ ಅಲ್ಲಿ ಬಂದು ಅವ್ರು ಆಕ್ಯುಪೈ ಆದ್ರಂದ್ರೆ ನೀವು 10 ಆಗಲೇ ಆಗ್ಬಿಟ್ಟಿದ್ದೀರಾ, 11ವರೆಗೆ ಸಿಗಲ್ಲ.
ಎಕ್ಸಾಸ್ಟ್ ಆಗಿ ಹೋಯ್ತದೆ.
ಎಕ್ಸಾಸ್ಟ್ ಆಯ್ತು ನಿಮ್ ಕೋಟಾ.
ಹಂಗಾಗಲ್ಲ. ಜನರಲ್ ಮೆರಿಟ್ ನಲ್ಲಿ ಎಲ್ಲಿ ತನಕ ವೇಕೆನ್ಸಿ ಇದೆ ಅಲ್ಲಿ ತನಕ
ಕೊಡ್ಬೋದು. So they would like to contend, press into service, my lord, this horizontal reservation as far as Hyderabad, Karnataka is concerned. Once your quota of 75 or 82 is exhausted, you don't come into the general merit quota.
ಈ ಜುರಿಸ್ಪ್ರುಡೆನ್ಸ್ಗೆ ಕಾಂಟ್ರರಿ ಹಾಕೋತ್ ಹೋಗ್ತದೆ ಅನ್ನೋದು
ಅಂತ ಅವ್ರು ಹೇಳ್ತಾರೆ. ಇದು ಹಾರಿಜಾಂಟಲ್ ರಿಸರ್ವೇಶನ್ ಬರಲ್ಲ.
ಹಾರಿಜಾಂಟಲ್ ವರ್ಟಿಕಲ್ ಬೇಡ್ರಿ.
ಹೌದು,
ಇದು ಯೂನಿಕ್ ಇದು ಅಂತ ನಿಮ್ ಕಂಟೆನ್ಷನ್. Understood.
Yes. My lord, they have given the illustration also, my lord. Sum and substance is only this much, my lord. My argument to that is, my reply to that is, neither it is horizontal reservation nor it is vertical reservation. The doctrine of the reservation under Article 14 and 16, my lord, are not at all applicable to 371J because it is totally on a different
ಪ್ಲೇನ್ ಮೇಲೆ ಬೇರೆನೇ ಅದು ಅಂತ.
ಹೌದು,
ರೀಸನ್ ಬೇಸ್ಡ್ ಇದೆ.
ಹೌದು.
ಹಂಗಾಗಿ ನೀವು ಏನೇ ಒಂದು ಸ್ಪೆಷಲ್ ಫ್ಯಾಕ್ಟರ್ ತರೋದಿದ್ರೆ ಆ ರೀಸನಲ್ ಎಲಿಮೆಂಟ್ಸ್ ಇರ್ಬೇಕು ಅದರಲ್ಲಿ, ನಾಟ್ ದೀಸ್ ಕನ್ವೆನ್ಷನಲ್ ಪಾಯಿಂಟ್ಸ್ ಎಟ್ ಆಲ್ ಅಂತ ನಿಮ್ ಕಂಟೆನ್ಷನ್.
I am drawing the, my lord, principle of applying HKE candidates, applying in the non-HKE region.
Correct. Therefore, that
It is a universal. It is a universal principle. General merit candidate can compete in the residuary cadre. You cannot restrict them in the Hyderabad.
In fact, it is not a part of law of reservation at all.
Yes.
That way.
Yes.
Because on his merit he comes there.
Yes.
That you cannot restrict,
Yes.
is your contention.
The earlier 2 notifications your lordships have seen. The those 2 notifications, my lord, which are subject matter, my lord, before my lords, my lord, and those 3 notification.
Earlier
16/1/2013, which is it becomes a subject matter. And my lord, 6/6/2020 and 15/6/2000.
6/6/2020.
6/6/2020 and 15/6/2022. These are the 2 notifications which said that even though one application is called for in respect of 2 cadres, first they will consider you, if you are applied under the HKE quota, you will be considered there. If your option is HKE cadre, you cannot come to
General
that is residuary cadre, that is rest of Karnataka, you cannot come. My lord, that was this notification. Subsequently, it was felt, my lord, that you are depriving the opportunity of these candidates who are otherwise meritorious can compete in the general merit quota. My lord, I say, my lord, HK is a reserved quota. Non-HK vacancies are unreserved quota. Therefore, they are entitled to compete. That embargo, which was created in these two circulars, were removed, my lord, by the notification dated 1/2/2023.
He also adds that the non-reserved category cannot have the tag of quota at all. And quota means what is reserved alone.
Yes.
First. As a concomitant of this, a person of Hyderabad, HK
371J.
371J
Reservation under 371J.
can always compete in the open market.
Yes. Other than 371J reservation.
That is outside, that means any reservation outside 371J also. Okay.
My lord, those two contention, my lord, of the petitioner, that horizontal reservation and vertical, some of them are argued, my lord, saying that it is a vertical reservation. It is not a vertical reservation. The principle enunciated in Indra Sahni's case cannot be made applicable. Yes, it cannot be made applicable. The principle enunciated in Indra Sahni's case is not imported into this, but it is a universal principle. Therefore, it is applicable even to 371J. Saying that Indra Sahni case is not applicable, therefore, you are not eligible for being allowed to compete in general merit category is not correct.
Even in the absence of Indra Sahni also, that would have
Yes.
been the position of the contention.
Yes, yes. And it is not a horizontal reservation to say that once the quota is complete, I cannot compete in the
It is exhausted.
exhausted.
Understood.
These are the two contention, my lord, as far as the reservation is concerned, my lord, of the in this circumstance. Now, coming to the question of the power of the governor, my lord, exercising, if my lords were to allow me to elaborate, my lord, I can say, my lord, with reference to, may I request your lordship kindly see, my lord, Article 163, my lord, and 160. Where does the power under Article 371J, the responsibility imposed, my lord, on the governor, they fall? In which of the part of the Constitution, my lord, the power specified under 371J falls? Some of them argued, my lord, he cannot delegate. Here there is no aid and advice of the government. All these contentions were, your lordship may recollect, the delegation of power by the governor to the government, which is not being provided. There is no scope, there is no aid and advice of the Council of Ministers. All these arguments were advanced. What is that nature of the responsibility that the governor, my lord, exercises, my lord, in terms of Article 371J? My respectful submission is, my lord, this chapter of part 6 of this Constitution, my lord, cannot be looked into, my lord, for the purpose of determining the nature of the nature of the power that is exercised by the governor. It is outside the scope of part 6, my lord, is my first submission. The principles involved in this part 6 cannot be imported, my lord, in exercise of the power of the governor, my lord, under 371J.
Except ascertaining whether he is governor or not. Allah, you may withdraw also, but we do not know.
Yes.
Because they say it is governor,
Yes.
then we have to see who is the governor of our state.
Yes.
Then how
Except,
we have to-
except that, my lord,
rest of the things, the power as such, he does not derive
the
from here.
normal powers exercised by the governor under the constitution as far as part 5, 6 is concerned, my lord, is not applicable.
Excluded.
Yes.
In other words, 153 ಅಷ್ಟೇ ಅಪ್ಲೈ ಆಗ್ತದೆ ನಿಮ್ contention.
ಇಲ್ಲ 160 ತಾವು ದಯಮಾಡಿ ಒಂದ್ಸರಿ ನೋಡಿ
160.
160.
Discharge of the function.
ಇದೊಂಥರ ಮಿಸ್ಲೇನಿಯಸ್ ಇದ್ದಂಗೆ. The president may make such provision as he thinks fit for discharge of the functions of the governor of a state in any contingencies not provided in this chapter.
Residuary power ಇದ್ದಂಗೆ.
ಹೌದು. Now that 371J is there, the president has said, you exercise the power under 371J.
Forget this part.
Yes, it may fall under 370, 160
At the most.
at the most. Now your lordship will kindly see 371J.
ಇಲ್ಲ ಬರಲ್ಲ ಅದು ಯಾಕೆ ಗೊತ್ತಾ? ಈವನ್ 160 ತೊಗೊಳ್ಳಿಕ್ ಬರಲ್ಲ. ಪ್ರೊವೈಡೆಡ್ ಫಾರ್ ಇನ್ ದಿಸ್ ಚಾಪ್ಟರ್ ಅಂತ.
ಹೌದು.
ಆ ಚಾಪ್ಟರ್ ನಲ್ಲಿ ಹೇಳುವಂತ ಇಶ್ಯೂಸ್ ಏನಿದಾವು ಆ ಇಶ್ಯೂಸ್ ಅನ್ನು ಅಡ್ರೆಸ್ ಮಾಡ್ಲಿಕ್ಕೆ ಪ್ರೆಸಿಡೆಂಟ್ ಮೇಸೆ ನೀನ್ ನೋಡಪ್ಪ ಹಿಂಗ್ ಮಾಡು ಅನ್ನೋ ಅರ್ಥದಲ್ಲಿ ಇದೆ. ಮೇ ಬಿ ಬಿಕಾಸ್ ವಿ ಡಿಡ್ ನಾಟ್ ಹ್ಯಾವ್ ಪ್ರಾವಿನ್ಷಿಯಲ್ ಗವರ್ನರ್ಸ್ ಎಟ್ ಆಲ್. We had only Governor General in council.
Lord, some of the functions have been carved out, my lord, in this chapter.
But
some of the-
essentially what you say is,
Yes.
ಈ ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಪವರ್ ಆಫ್ ದಿ ಗವರ್ನರ್ ಇದೆಯಲ್ಲ
ಅದನ್ನ
ತಲೆಯಿಂದ ತೆಗೆದಿಡಿ ಅಂತ
ಹೌದು.
ಹೇಳ್ತಾ ಇದ್ದೆ.
Yes.
ಅದು ಅಲ್ಲ, ಅದು 371J ಆ ರೀತಿ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ.
ಹೌದು.
ಆ ಸ್ಕೀಮೇ ಬೇರೆ, ಈ ಸ್ಕೀಮೇ ಬೇರೆ ಅನ್ನೋದು.
Principles of saying aid and advice of the council of
ಅದೆಲ್ಲ
ministers,
ಬರೋದಿಲ್ಲ.
independent exercise of the power without reference to the government. No, all these things cannot be, my lord, pressed into service. Yes. Yes.
He further submits that Article 371J, because of its very special feature, is a standalone provision, and that cannot be construed keeping in view the provisions of Part 6, maybe except Article 160.
With regard to exercise of power by the governor.
In respect of all powers to be exercised by the governor under 371J order made by president.
Yes.
Under presidential order, to borrow terminology of our Lakshmi Narayana, under the presidential order issued under Article 371J. ಊಟ ಮಾಡಿ ಬರ್ಬೋದಾ?
ಆಯ್ತು.
But afternoon.
I think my lords are sitting, my lord.
Friday ಕೊಡ್ತಾ ಇದೆ. ನಾವು ಇದ್ರ ಸಲುವಾಗಿನೇ we have requested him.
I think my lords are sitting, my lord, in portal number 1, my lord, for
Portal number 1.
at what time, my lord, we should assemble here approximately.
ಅದಾದ್ಮೇಲೆ ಇಲ್ಲ ಇಲ್ಲ ನಮ್ಗೆ. ಇದೆಯಾ? ಮೋಸ್ಟ್ಲಿ ಹಂಗಿಲ್ಲ ನೋಟಿಫಿಕೇಶನ್. ಇದೆಯಾ? After this will reconstitute ಅಂತ ಇದೆಯಾ? ಓಕೆ. ಹಾಗಿದ್ರೆ ಮೋಸ್ಟ್ಲಿ ಎಷ್ಟೊತ್ತಾಗತ್ತೆ ಅಂತ ಗೊತ್ತಾಗಲ್ಲ. ನಾವು ಬಂದ ತಕ್ಷಣ ನಿಮ್ಗೆ ವಿಲ್ ಕಾಲ್ ಯು. ನಿಮ್ಮ ಫೋನ್ ನಂಬರ್
My lord, we will be here only, my lord.
ಬೇಡ, ನಾಲ್ಕು ದಿವಸ ವೇಟ್ ಮಾಡೋದು ಬೇಡ. ಅಲ್ಲಿಂದ ನಾವು ಬಿಟ್ಟ ತಕ್ಷಣ
Yes.
ಅವರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ ವಿಲ್ ಟೆಲ್.
Please.
ಈ ಲಾಯರ್ ಶುಡ್ ಹ್ಯಾವ್ ಸಮ್ ಲೀಸರ್. ಅಟ್ ಲೀಸ್ಟ್ ಹಿಂಗೆ ಹೊರಗೆ ಬಂದಾಗ ಅಟ್ ಲೀಸ್ಟ್ ಇಲ್ಲ ಕೂತ್ಕೋಬೇಕು ಅನ್ನೆಸೆಸರಿ. ಎನಿವೆ ಜಡ್ಜ್ ಇಲ್ದಂತ ಕೋರ್ಟ್ನಲ್ಲಿ ಕೂಡ್ಲಿಕ್ಕೆ ಖುಷಿನೇ ಎಲ್ಲರಿಗೂ. ಜಿ ಮಧ್ಯಾಹ್ನ ಬನ್ನಿ.
Please, my lords, I'll be there.
I will send words.
Please.
Yes.
ಅವ್ರು ಹಿಂಗೆ ಮಾಡ್ಕೊಳ್ತಾರಪ್ಪ.
ಮಾಡಿದೀವಿ ಅಂತ.
ಅಂದ್ರೆ ಇಲ್ಲಿ ಇಟ್ಕೊಂಡಿದ್ದು. Okay, that is all. 2:30. 10 bench.
ಯಾರು ಬರಲ್ಲ ನಮ್ದೇ ಅದನ್ನ. ಲೀಗಲ್ ಬರ್ತಾ ಇಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರೆ ಅದು ಹೌದಾ ಬರೀ ಕೋರ್ಟ್ ಬರುತ್ತೆ. ಓಕೆ ಹಂಗ್ ಮಾಡಿ.
kind attention
Okay.
to paragraph 12. Page 60,
Page 60,
63, my lord. It
Three.
commences from page
2015
60.
8.
How? Paragraph,
This considered order under 371D.
howದು? Alla, my lord, I am not on the ratio laid down or the order passed. I just want, because I do not have the text of 371D of the presidential order.
Order
complete.
of Andhra.
Andhra. After 371 days, some orders are issued.
Hmm.
That has been extracted, my lord, and dealt with by the court, my lord.
Hmm.
Paragraph 12, my lord.
The presidential order.
Yes. Paragraph 12, my lord. This was difficulty with, my lord, civil post. It was not in regard to the post in the government organization. There was a dispute whether 371D is confined only to civil post or it is also includes
12 entity.
to other. In that context, my lord, the matter went up to Supreme Court. May I request your lordship kindly see, my lord, paragraph
12.
21, my lord, I'm sorry, 21. It's an extract of the order, my lord.
Ah.
The government of Andhra Pradesh, general administration, so and so, my lord. The
Date
entire
was-
order has been extracted.
Correct.
In that, my lord, first paragraph,
In terms of para 8.
yes. The word commences, the remaining 20, about 5 lines, my lord, in that first paragraph. The remaining 20% of the post are open posts for which the locals, non-locals have to be considered on the basis of the combined merit. This aspect has already been clarified in the UO note. Further read as the government have issued instruction to in the GO. The third read above in the manner in which the posts have to be filled up. Then the government has re-examined the matter of filling up the post prescribed in GO. Third read above. Accordingly, it is decided that filling up of the post under the direct recruitment, the first 20% of the post should be filled following the combined merit list of the locals and non-locals, and thereafter remaining 80%, that is reserved category, of the post shall be filled by the local only. Correct. Now, your lordship may recollect, my lord, in our 2013 order, there are 75:80. In case of, my lord, class 1 officers, your lordship will kindly see, my lord, the 2013 order in this book, my lord, the government book.
Six 2013.
Yes, my lord. 6/11/2013 order. Your lordship finds at page number 12 of this book, my lord.
Correct.
Organization of local cadres. In case of class 1, my lord, it is kindly see 2, my lord, 75%. In case of D class, my lord, it is 80%. This remaining 25%, my lord, becomes unreserved category, my lord, in the Hyderabad, Karnataka vacancies.
Subsection 2, the class 2 is 75%,
Yes.
3 is 80%.
My lord, class 2, my lord, refers to group A post and B post.
Correct. Idu group
This
C.
is group D.
Which one? C.
How do?
C and D.
C and D.
Ah.
Idralle, in this category, my lord, the remaining 25%
Ah.
is unreserved. 80% is reserved. Just now, your lordships have seen, my lord, the presidential order, my lord, of 371D, Andhra. That 20% should be filled up first.
Because that very order says like that.
Yes. Here also, in this case, my lord, as far as Karnataka is, my lord, Hyderabad, Karnataka vacancies are, cadre is concerned, my lord, only 85% of the posts are reserved for the domicile of Hyderabad, Karnataka. And 25%, my lord, are not reserved, unreserved category.
General category.
General category. For this, the HKE person also will compete.
And it cannot be called as quota at all. Easy for submission.
Yes. Therefore, this universal application of reserved and non-reserved is recognized everywhere, wherever, my lord, in our country, my lord, it is like that.
So that will be open market where he can be in this and that, depending if he scores more, he may fit here. If he does not score more, he will be fitting other side.
When do you make selection of that? Whether you make 75% first or 25% first?
No, open market first.
My lord, if that is the case, my lord, these two notifications which you are dealing with, my lord, now
are consistent with that principle.
ಅಲ್ಲಿ ಏನಂದ್ಬಿಟ್ರು 6-6 notification and 15-6 notification ನಲ್ಲಿ if you have applied for it, you are not eligible here. If your option is Hyderabad, Karnataka, you are not eligible in this category. So that creating an embargo upon the
ಎರಡು ಕೋಟಾ ಅಂತಾನೆ ಟ್ರೀಟ್ ಮಾಡಿಬಿಟ್ರು ನಾವು.
ಹೌದು.
ಓನ್ಲಿ ಒಂದನ್ನು ಮಾತ್ರ ಕೋಟಾ ಆಗಿ ಟ್ರೀಟ್ ಮಾಡ್ಲಿಕ್ಕೆ.
ನೀವು ಇದನ್ನ ಮಾಡಿದ್ರೆ ಇಲ್ಲಿಲ್ಲ.
As if they are mutually exclusive ಅನ್ನೋ ರೀತಿ ಮಾಡಿಬಿಟ್ರು. That they could not have done. This 20% or 25% ಇದೆ. ಅದಕ್ಕೆ ನೀವು ಕೋಟಾ ಅನ್ಲಿಕ್ಕೆ ಬರಲ್ಲ.
ಹೌದು. ಎಲ್ಲರೂ ಕಾಂಪೀಟ್ ಮಾಡಬಹುದು.
Anybody can compete. It's an open market.
Open market.
ರವೀಂದ್ರ ಭಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಟೈಪ್ ಮಾಡ್ಕೋಬೇಕಂತ ಅನ್ನೋದು ನಿಮ್ ಕಂಟೆನ್ಷನ್.
ಅಲ್ಲಿ ಹೋಗ್ಬಿಟ್ರೆ ಮತ್ತೆ ಅದನ್ನ ಅಪ್ಲೈ ಆಗುತ್ತೆ ಅಂತ ಹೇಳ್ಬಿಡ್ತಾರೆ ನಮ್ಗೆ. ನಾವು ಅಲ್ಲಿ ಹೋಗಂಗಿಲ್ಲ.
Even otherwise it is like that.
Universal principle, non-reserved first, reserved subsequently, because a reserved category candidate will first stand in the queue of non-reserved.
Is 25% and 75% is for the local cadre and the residual cadre.
ಹೌದು.
Now, among this 75%, all other reservations will come in play.
Yes, my lord. That is taken. That is no quarrel about that, my lord. That's not.
That 25% also, all those things.
Oh, all those things will be there. Now, your lords. Now that my lords have asked this, my lord, kindly go to the my lord paragraph 13, page 17, my lord. In this very same, just 2 pages.
13. Protection, promotion of right of local.
My lord, 13, my lord, paragraph 13. State level officer or institution or affects institution. Idರಲ್ಲಿ 8%.
8% of the posts in the following state level officers, state level.
For the entire state, whichever.
State, ಅಲ್ಲೇ 8%.
Hyderabad, Karnataka.
How?
And within that 8%, all that.
No, that is there. Yes. This 8% becomes reserved category.
Within that.
Within that. If I am belonging to Hyderabad, Karnataka, I will apply for the state level institutions. My application will be considered against 92% first, unreserved. Thereafter, reserved 8%. If I am not selected in the state level institution, I will be considered under 8, exclusively meant for Hyderabad, Karnataka area. Hello, this is how, my lord, it works.
They are not mutually exclusive.
Yes.
Is your contention.
This principle, your lordships have seen, my lord, even in the presidential order and the 371D also. 20 is to 80. First consider 20, which is non-reserved. Thereafter consider 80, reserved.
ಆ ರೀತಿ ಟೆಕ್ಸ್ಟ್ ಇಲ್ಲ ಇದು ನಮ್ದ್ರಲ್ಲಿ.
ಇದ್ರಾಗಿಲ್ಲ.
But we can take, draw.
This is how it works. This is how it works. And this is how it should work also.
So you mean to say that the contention that they work in two silos.
Yes.
Independent of relationship is not correct.
If you are going there, you don't come here. That should not be, my lord. That is how, my lord, it has been now corrected. This 1/2/2023, my lord, has remedied that mischief. Lord, I will deal with that, my lord, doctrine of mischief, Hayden's case. There are judgment which says, if any mischief is remedied, the court should take the path which has resulted in remedying the mischief. My lord, your lordships have seen, my lord, the other day while.
Sir, head-on's principle. I think Edward Coke's judgment. It
Yes.
is very old judgment.
Very bold judgment, my lord.
Whether that applies to, that applies to, its application is confined to only statutes, or it is applicable to delegated legislation like this also,
Yes.
what the courts have said. Because that was a case where a legislation.
Lord, it is a doctrine, my lord.
It's understood.
It's a doctrine. Wherever, my lord, the legislature or, my lord, the executives find that there is a rule which requires to remedy, which is causing trouble, which is creating hurdle or whatever it is. If that is removed, the court should take the path of the remedy that the legislature or the executives have found to remedy the mischief.
I'll put it little articulately. I'll try to put it more articulately. In Head-on's case, the English Parliament has passed a legislation which said whenever any vessel, that is ship, boat, etc., carries sheep on a sail, it should have the complete cover around so that the diseases, if any, with this herd is suffering from, shall not spread to other sheep in other ships. That was the principle. Because of Irish sea wave action, the sheep in one particular vessel were completely washed away. And the cargo owner, he brought an action against the ship owner. There the contention was, his contention was, had you put the fence around, protective fence around your sheep, my sheep would not have been washed away by tidal action. To that, the House of Lords said, the object of legislation is not against tidal action, but against the mischief, namely spreading of disease from one ship to another. This is what we have been taught in law by our great professor J.S. Patil in jurisprudence. In fact, head-on principle is referred by 12th edition of Procedural sedition in jurisprudence separately. Our question is, now understood, what you want to say is, whether the source of law is Parliament or it is a quasi-legislative instrument like where rules are made, etc. Even there this doctrine is applicable, is your submission.
This 1/2/2023 has remedied the difficulty or embargo caused, my lord, to the Hyderabad Karnataka area. I only say recognize that
You identified that and remedied.
This has been remedied. Kindly protect the remedy that has been thought by the legislature or, my lord, the executives. My lord, your lordships have seen, my lord, the earlier order of the KAT, the Lordship Justice Bhaktavasala's order. Similar contention. The law was holding the field. And it was applicable, my lord, to all recruitments at that point of time, even the same mistakes which were committed. Ignoring that, my lord, again the same mistake is done. Again, the court are called upon, my lord, to decide on this, whether a single application, creating an embargo on HKE.
Welcome. And senior advocate submits.
ಅದು ಮಿಸ್ಚೀಫ್ ಬಂದಾಗ ನಾನು ಜಜ್ಮೆಂಟ್ಸ್ ಎಲ್ಲ ಇದು ಹೇಳ್ತೀನಿ ಅವ್ರ ಜೊತೆಗೆ.
Very well. The senior advocate submits that. The order that was impugned before the KAT was remedial in nature, in as much as the earlier orders
Created an anomaly.
had created bar between the quota and reserved category, more particularly to be understood in the light of Justice
Ravindra
Bhatt's, Honorable Justice Ravindra Bhatt's judgment, amongst other. And that having been done, head-on's case, HEYDON', which enacts, which recognizes rule against remedying the mischief, becomes applicable.
Now, coming back to the question.
You mean to say, if there is a mistake or mischief, that can be remedied at any point of time after the commencement of the recruitment process?
No, I will deal with that, my lord. I will deal with that separately, my lord. I will deal with that separately. My lord, if any right constitutionally recognized right has been conferred upon somebody, if there is an attempt to take away that.
No, will you make separate?
Yes.
Now, what is the other point?
Now how the governor acts, my lord, under 2013. The functions of the governor, my lord, responsibility under the 2013, not act, my lord,
Order.
sorry, order, 2013 order. I'll just, my lord, take your lordship to some of the provisions, my lord, some of the paragraphs, my lord, in this 2013 order to find out whether it is the exclusive power of the governor or the exclusive
And advice, etc.
exclusive responsibility of the governor, or it is collective responsibility of the government and the governor.
No, that you have said, if
Yes.
part 6 is removed,
Yes.
then this again, it will be repetition argument. It comes in that only.
No, my lord. I am referring to some of the order, my lord, paragraphs in the order, where it's without going into, my lord, part 6. This order itself says how the government and the governor will have to act in coordination, my lord, to achieve the object of 371J, my lord, will be my respected submission. That is an independent argument. It is not applicable, it is independent. Now, with reference to the paragraphs, my lord, in 2013 order, it has been specifically provided, my lord, what are the role of the government, what is the role of the governor, and how, my lord, ultimately with the coordinate effort, my lord, of all the department, my lord, the ultimate object is sought to be achieved. Now, your lordship will kindly see, my lord.
No, all right, we'll come to we want to understand the question.
Yes.
The governor is the designate in this order.
Yes,
The power is a delegate.
yes,
Delegate of the president.
yes.
Whether governor being the delegate, is he acts in his independent discretion or does he take the aid and advice of Council of Ministers?
Not necessary, madam.
In other words, the word governor, you mean to say, cannot be approximated to government.
My lord, it is a mixture of all, my lord. If my lords were to see, my lord, some of the paragraphs, my lord, in 2013 order and this subsequent amendment, and my lord, the Constitution of Hyderabad Development Board, the responsibility on them, and my lord, the rules made thereunder, which will indicate, my lord, that there has to be a coordination between the governor's office and, my lord, the government, on all wings of the government.
Governor cannot act without assistance is one thing.
Yes,
Governor acting on the aid and advice of the Council of Ministers is another.
yes.
That concept you are saying is alien to this order.
Alien.
But he may take the help of many departments is another thing.
Yes,
Because that is accommodated in the 2013 order.
yes,
That's your submission.
yes. And there are some provisions which are brought to my lord's notice.
Where word government is.
Notwithstanding anything contained in any rules, this will have a overriding effect, is one aspect, my lord, which has been canvassed before my lords. Asking the government to interpret my order, that is one of the facets, my lord, of the arguments. All this will have to be taken into consideration, my lord, with reference to, my lord, 2013 order. I will be able to demonstrate that, my lord, even this not, your lordships have seen, my lord, in other constitutional amendment, 371D, and it starts with a non-obstante clause, notwithstanding anything. Now, a care has been taken, my lord, in this. When I say notwithstanding from this, at the same time, my lord, there is a direction to the government. All those rules which are contrary to this, which are coming in it is a hurdle in giving effect to 2013 order and 271J. You make amendment so that it is in conformity with this 2013 order.
So primacy is to this.
Yes. If there is any conflict,
You
bring in line with this. See that the object is achieved. Tooristin. Now,
Let us see.
paragraph 11.
Let us see how governor and government are understood.
Yes.
The draftsman.
Lord, that is precisely, my lord, my concern, my lord, as far as this argument is concerned.
Yes.
Kindly see, my lord, paragraph 10. Paragraph 9, 10 and 11. Page 16, my lord.
Power to authorize issue of direction.
Yes. The governor may by order require the state government to issue such direction as may be necessary expedient for the purpose of giving effect to this order to any local authority or a body, organization, and such local authority body or the organization shall comply with such direction. So governor may say, this rule is coming in the way of implementing. You amend like this, you do like this.
This order is made by governor himself.
Yaudu.
He himself says like this.
I will give direction. You should comply with this. So he is not, my lord, waiting for the aid and advice.
On
He
the
is
other hand,
saying,
it is reverse case.
yes. The government may, for the purpose of issuing any direction under subparagraph, or for satisfying itself that any direction issued under the subparagraph have been complied with, requires any order in writing, any local authority or body or organization to furnish them such information or report of a particulars as may be specified in the order, such local authority shall comply with such orders. Now kindly see, my lord,
How he derives power to make this class under which?
371J only. This is how he wants to exercise his exercise his duty.
No, that governor's order.
ಮುಂದೆ ಮತ್ತೆ ಬರ್ತೀನಿ. They will have to be placed before the legislature ಅಂತಾನೂ ಇದೆ. ಈಗ ಏನ್ ಹೇಳ್ತಾರೆ, ಗವರ್ನರ್ ಏನ್ ಹೇಳಿದ್ಮೇಲೆ it should be placed before the house. Necessary amendment have to be done so that there is no conflict of the existing rules or the rules made under the 2013 order or
Just show us source of power to enact this paragraph.
371J only, my lord.
Kindly read.
Yes. Flag ಹಾಕಂತ ಹೇಳ್ತೀನಿ. The president may, by an order made in respect of to the state, provide for any special, kindly mark this, my lord, provide any special responsibility of the governor for establishment of a separate development board for Hyderabad, Karnataka region with the provisions that a report on the working of the board will be placed with, each year before the state legislative assembly, equitable allocation of funds for development of expenditure over the said region. Then C, equitable opportunities and facility for the purpose of belonging of the said region in the matter of public employment, education, vocal training, subject to the requirement of the state as a whole. Then your lordship will, to achieve this clause, subsection 1, sub-article 1, an order made under subsection C of the clause A may provide for reservation of a proportion of seats in the that is not required. B, identification of the post or class of post under the state government in any body or organization under the control of the state government in Hyderabad, Karnataka region, and the reservation of proportion of such post for the person who belong to that region by birth or by domicile, or for the appointment thereto by direct recruitment or by promotion in any of the manner as may be specified in the order.
So 371J
To C.
C. Read with 1C.
Yes. Therefore, my lord, in exercise, my lord, in discharge of his responsibility, this mechanism has been put in place by the governor, wherein the government, in some cases, there will be a direction to the government. And my lord, 2-3 provision will make it clear, my lord, how it works. And if there were some shortcomings, my lord, and thereafter amendment is made. So it goes before the legislature, finally, to bring about any rules which have been suggested by the governor himself. And if those rules are, my lord, placed before the house, if necessary amendments are made, then, my lord, there will not be any conflicting provision, my lord, under 2013 Act, and, my lord, the rest of the service rules, my lord, applicable to others. Ultimately, my lord, this paragraph 10, my lord, will have to be satisfied. Order to have overriding effect. The provisions of this order shall have the effect notwithstanding anything contained in any act or the rules regulation or bylaws made thereunder before or after the commencement of this order in respect of the direct recruitment, promotion, post under the state government or the local authority or the body organization. Ultimately, my lord, these 2013 rules, my lord, whatever is specified, the object is sought to be achieved, my lord, will have the effect of notwithstanding anything contained in any other rules, my lord, of service rules. To achieve this, my lord, what is that is required to be done?
Now, how can he say that even you can override the act?
My lord, I will come to that later, my lord. He will suggest, this is the rule which is coming in my way. Kindly amend it, place it before the house, get an statute approved. Can I straight away take, my lord, to my lord's attention, my lord, to page number 60, my lord. This is an amendment to 2013 orders. Paragraph 15 at page 63, my lord. This is how notwithstanding will be achieved by following rule 15, paragraph 15, page 63 at the bottom, my lord. Page 63.
This is also by the governor.
Howdo? This is an amendment to 2013 order that your lordship will find, my lord, at page 60, my lord. Following orders made by the governor is hereby published for general information. This is the order by the governor himself.
Which paragraph we have to
15,
say?
my lord. 15.
Power to make rules.
Yes. State government may by a notification, make rules to carry out the purpose of this order. And clause 2, important, my lord.
Laying procedure.
Every rule so made shall, as soon as may be, after it is made, to be laid before each house of the legislature. If any service rules, my lord, is in contravention or, my lord, in conflict with the 2013 rules, for example, reservation, it can be, my lord, allocation of a post, whatever the existing rules of the state are there, to bring on par with or, my lord, in conformity with 2013 order, the state government is required to make an amendment and place it before the house to achieve ultimately the object of this act, object of this 271J and, my lord, the orders made thereunder.
So governor is super legislature.
He is only, my lord, I can put it in this way, my lord, the responsibility that has been entrusted upon him, he would like to exercise the power, my lord, in this way without conflicting, my lord, with any of the power. He wants to bring in, my lord, straight away, my lord, bring the legislation on par, with, my lord, in conformity with the this order to achieve the object of 371J, to bring about uniformity, my lord, in the development, my lord, between the Hyderabad Karnataka region and the rest of the state.
So in effect, he is a super legislature.
But I do not want to put it in.
Yes, that will be like that.
He is not
Accepting-
making, Lord, he is not making. He is asking the government to make it.
No, the one provision,
Yes.
power to
Give direction.
and the other one,
Lord,
overriding effect.
Ultimately, my lord, the direction will go to the legislatures, my lord.
No, that makes no, many rules provide for, many statutes provide for laying procedure.
Lord,
In fact, CH-07 in
my lord,
law in the making has.
I am
stated-
only saying, my lord, all care is taken to see that, my lord, it is done in accordance with the, my lord, the constitutional mechanism. Both legislature.
Atlas cycles versus so and so. A governor in our federal setup a governor is appointed by the central government. So if that power is given, that virtually amounts to placing the legislature at his feet. Whether that is constitutionally permissible is the question.
My lord, it
He
is the,
he
it is
says-
not the power, my lord. It is the responsibility.
But only we are on different dictionaries. You are holding some other dictionary. We are holding other dictionary, but your answer may not be correct. Our answer may be for this reason. For what I am saying now from the bench is supported by jurisprudential material, which is called Hoffeld's trapezium. You are saying responsibility. We are saying power. In fact, Hoffeld, which the apex court treated in one, Salmon treats it also. HLA Hart treats it also. The power, immunity, right, duty, liability, disability. Only within these 6, it has to, within the 8, it has to fit in. There is no meaning that to the word responsibility. Question is, we are in a federal structure. Federal feature is a basic feature of the Constitution. We have to interpret the order of the governor, the order of the president, the order of the governor, without breaching the principle of federalism. If we accept that, assumedly, tomorrow, suppose some other rival parties, one is in the center, another is at the state, it can virtually hijack the legislature of particular state if we accept your contention. There are judgments. I will come back to judgments also after hearing you is another thing. The laying procedure, which C.K. Allen in his famous book, Law in the Making, has treated, apex court has referred to him. Laying procedure is only the administrative control, legislative control of administrative action. That's what apex court said in Atlas cycles. Beyond this, nothing. Merely because it is the rules are laid for the House consideration for 30 days, the rules do not attain the status of a statute, though they are laid in the parliament.
My lord, laying a rule, my lord, before the legislature is again a very big, my lord, the concept.
Correct.
There are several judgments, my
Several
lord,
judgments.
several judgments on laying, my
Laying
lord,
procedure itself.
what is the effect of laying?
Is, in fact, there are judgments which we agree with you.
My lord, I will not go to that extent, my lord.
Go.
My lord,
I request you to walk with us.
my lord, I am only saying, my lord, all care is taken.
That means-
My lord, he will not be, my lord.
Now, your submission.
Yes,
Kindly see this, the order.
yes.
That the governor can, notwithstanding anything he wants, virtually it is like he becoming a dictator. Arguably, he wants to become super legislature because he says, notwithstanding the state legislations. This is what Henry VIII used to do in England, in English history. If we see that by Arnold Toynbee, he refers to that one. That is not the object of our constitution. Kindly see the provisions.
Yes.
We are, this is only a discussion. This is only a discussion, so that what may be the true correct position, ultimately, we also do not know. We may, while making this, kindly see the power to authorize issue of direction, we can understand, provided that you read it in limits. He cannot issue any direction contrary to the legislation. And he himself is saying, if this power were to be given by the president, we would have understood. Still we doubt, because federalism, after Sarkaria Commission report, the federalism has been accepted by the Supreme Court as one of the basic features of the Constitution. So any construction of instruments like this should be consistent with federal principle.
Lord, I'm only bringing to my lord's notice, my lord, in a very limited, my lord, the area when the petitioners contended that governor, my lord, is not acting in the aid and advice. All those principles they have brought into, my lord, even though, my lord, that is not the scope. That is not the scope.
No, up to that, we perhaps, we don't have much divergence.
Yes.
At least arguable case we have. But governor saying that,
Lord,
my dicta
Lord, that is,
overrides the statutes of the state.
my lord, that is not the issue, my lord, in this matter. I'm only for a limited purpose saying, my lord, governor has, my lord, has laid this mechanism under this rule, my lord. When it comes to testing the validity and all that, my lord, perhaps, my lord, I will be in a position to answer, my lord, for each and every question, my lord. Maybe I will have a justification, my lord, for making this rule. Oh, I'm only saying, my lord, the governor is, my lord, has laid his mechanism, my lord, in this 2013 order. It cannot be said, my lord, that you should have aid and advice of the
That we
Yes.
understand. That
Only for that limited purpose.
arguably,
Yes.
arguably, there is some point which you want to make in keeping chapter 6, the part
Yes.
4
Yes.
or 6 perhaps, part 6 in a capsule, we can understand, we can treat that argument. But your contention that governor
No, my lord,
need not follow the
no,
statutes at
no.
all.
my lord, I am not on that question only, my lord. I am only on the question. These are the mechanism that the governor has put in place, my lord, in this 2013 order.
Why
We
we-
are not testing, my lord, the validity or otherwise of these provisions, my lord, because that is not the question before my lords, my lord, in these matters. What is the question before my lords is those orders of the state government which are outside the purview of 371J. It is nothing to do with 371J. Those orders of the government, my lord, of 15/1/2022 and 6/6/2022, 15/1/2023 and 1/2/2023, my lord, they are the only, my lord, matters before my lords. By any stretch of imagination, my lord, it will not fall under 271J. Incidentally, because they have made all these contention raised, my lord, I am only replying to that, my lord. These are not the contention, my lord, in the application.
They may not take up. These
Yes.
contentions arise because of the submissions at the part. Because comprehensively we are looking at this one.
Yes.
Finally, see, there are statutes, for example, Civil Services Act is there, 1978.
Lord, Article 311 itself is there. 309 is there.
So if you say, no, fortunately, governor does not say, notwithstanding anything contained in the constitution. We can understand. This is a debate. After we have great respect for the office of the governor, is another thing. But 1978 Act.
Maybe, my lord, governor thought, my lord, the absence of notwithstanding in the article itself. He thought I can make it. He may not have the intention to override, my lord, all provisions. Maybe in an anxiety to see that, my lord, that there is no conflict of rules made by him and the rules of the state government which are prevailing. Should we continue on Friday, my lord? I think your lordship have to raise now.
No. Order to have overriding provisions of this order shall have anything contained in any act or rule, regulation, etc. But your one answer is we may not travel up to this level at all.
Yes.
We are only the construing various provisions of this.
Yes. My lord, Article 16, 14, 15 and 16. And my lord, whether it has violated the doctrine of change of the rules of the game in the midst of the recruitment. These are the two major things, my lord, and the courts, my lord, the tribunal has considered this aspect, and even the learned single judge also, my lord, considered those things. Whether it would be justified, my lord, under the circumstance to create an embargo upon the candidates of Hyderabad, Karnataka area from competing, my lord, against the vacancies available, my lord, in the rest of the state. That will be sum and substance of, my lord, the contention, my lord, that would be before. Since they have raised all these questions, my lord, only to reply that, my lord. Otherwise, my case will be confined only to these things, my lord, these two aspects.
Yes. Right, right.
Please,
ಸುಮಾರು ಅರೌಂಡ್ 11 o'clock ಬಂದ್ಬಿಡಿ ಫ್ರೈಡೆ.
please,
ಒಂದ್ 2-3 ಮ್ಯಾಟರ್ ಮುಗಿಸ್ಕೊಳ್ತೀವಿ.
please,
ಆದ ತಕ್ಷಣ ವಿಲ್ ಜಸ್ಟ್ ಕಾಲ್ ದೆಮ್.
please.
Thank you. Thank you. Government, just look into C.K. Allen, law in the making. He deals with laying procedure, which Apex Court has adopted Allen's view in at least 3 judgments. Okay. One is Atlas cycle.